motion. Myself, Mkhwebane, this is the Office of the Public Protector and others, case number 023495 of 2023.
May it please you, my Lord. We propose to address 5 topics. The first is the declaratory order, together with the mandamus, and the notice of motion. It's in various places, but I'm using the one at item 12, page 18 to 10. The declaratory order is paragraph 2, which is declaring the conduct of the first and or second respondent in refusing to pay the applicant the gratuity due and payable to her to be unconstitutional and invalid in terms of section 172(1)(a), and the related mandamus is at page 1811, which is paragraph 3, granting just and equitable remedies in terms of section 172(1)(b), including but not limited to severance and or an order directing the first and second respondent to take the necessary steps to ensure payment of the gratuity forthwith and or by no later than 30 days after the date of this order. So that will be item number 1. I'll demonstrate to your Lordship why there is no clear right established. And then the next is to address the prayer 5, which is the declaration that the conduct of the respondents is in breach of the Basic Conditions of Employment Act. It says breach of clause 3, but it should be section 32 of the BCEA, according to the argument. In fact, terms of section 3 of the BCEA. So that will be the second topic, is to address the BCEA cause of action. The third topic is to address the review under PAJA, and that is paragraph 6 of the notice of motion. The fourth topic is to address the review under legality. It is also encapsulated in paragraph 6 of the notice of motion. The last topic is costs. So if I could then start with the declaratory relief. Yes, my Lord, I'm reminded, I almost forgot that I had planned to hand up to your Lordship the documents that should have been removed from case lines, but they are still there in light of the judgment by Justice Van Nieuwenhuizen. So it's just to indicate which ones were removed, so that when your Lordship reads through this, you don't get yourself confused.
Removed in what sense, Mr.
Because they were struck out.
Oh, I see.
Yes. And so with a strikeout, if it's a paragraph, you black it out. If it's an actual affidavit, you remove it from the file. But that doesn't seem to have happened. So it's just to hand you these documents and say, if you see these documents in case lines, ignore them.
I shouldn't consider them for my determination.
Yes, indeed. Maybe it's easier to just tell you where they appear in the pages rather than giving you a hard copy. So
yes.
They appear at item 02107 to item 02160.
160.
Yes. 02160, and the first is 02107. So that is what was struck out, so that should not be considered. So if I could then return to the declaratory order. The declaratory order is based first on the conditions of service. Number 2, on some selected provisions of the Constitution. Number 3, on the BCEA. And number 4, on the Public Protector Act But in order to succeed, the applicant must prove a clear right, because what he seeks is a final relief. And because she also seeks a mandamus under paragraph 3 of the notice of motion, they must satisfy the requirement for a final interdict, which are contained in Setlogelo versus Setlogelo. And your Lordship knows this. There are 3. They must demonstrate a clear right, a threatened invasion or an actual invasion of that right, and the absence of satisfactory alternatives. Yesterday, we heard that she says she only needs to establish a prima facie right. That is incorrect. An applicant for final relief must satisfy the requirements in Setlogelo versus Setlogelo. The fact that this is constitutional relief against organs of state does not unshackle the applicant from the burden to prove the elements for final relief. The fact that you say, I want a declaration of unconstitutionality, does not mean you must not establish a clear right. And this applies across the orders. It applies to the declaration, it applies to the claim under the BCA, which is framed as a mandamus, but it also applies to the PAJA case. Now, on PAJA, the point is also trite. It's made in Zuma versus NDPP, the judgment reported in 2009, Volume 2, SA 277. It's a judgment by the SCA at paragraphs 26 and 27. Not only do they make the point about the need to establish a clear right when one approaches a court for final relief, but they also make it clear what the standard of proof is, that the Plascon-Evans standard applies. So nothing really changes on the law just because the label attached is constitutional relief. There is still a burden to discharge on the part of the applicant. So then, as an introduction to the declaratory relief, there are 2 preliminary questions to be addressed. The first is, what is the status of the conditions of service? And the second is, what is the status of the applicant? Both of these topics seem to have been elided yesterday. In so far as the conditions of service are concerned, the starting point is the Constitution in section 219, which establishes the basis for the conditions of service. The full Constitution, and this will surprise you, my Lord, but my attorneys managed to copy the whole Constitution, and it appears at item 20 from 1908. The relevant section is 1986, which deals with the remuneration of persons holding public office. And section 2195 says that national legislation must establish frameworks for determining the salaries, allowances, and benefits of judges, the public protector, the auditor general, and members of any commission provided for in the Constitution, including the Broadcasting Authority, referred to in section 192. So what we know from that is that the Constitution itself does not determine the salaries, allowances, and benefits, nor does it require the national legislation to determine the salaries, allowances, and benefits. It requires the national legislation only to set out the framework for the determination of the salaries, allowances, and benefits. The national legislation that has been passed pursuant to Section 219, subsection 5, that is relevant to the Public Protector is the Public Protector Act itself. It is also included in the authorities bundle, and it starts at page 2052. And it deals in express terms with the framework for the determination of the salaries, allowances, and benefits. And you will find this at section 2 thereof. Now, there's some explanation needed here because there's confusion in the founding affidavit. Section 2, subsection 2 was inserted into the Act on the 1st of April 2019. Prior to that, the previous section required the National Assembly to determine the salaries, and then it had a final phrase, conditions of employment. That was the previous before 2019. That was then deleted by the legislature. The confusion really arises because in paragraph 57 of the founding affidavit of the applicant, she quotes the old unamended section. The section from 2019, 1st of April 2019, is the section that appears at 20/2054. And what that requires is that it's no longer determined by the National Assembly, but what happens is a two-stage process. One is that the Public Protector shall be entitled to such salary allowances and benefits as determined by the President from time to time by notice in the Gazette after taking into consideration the recommendations of the Independent Commission. And that Independent Commission is defined at item 20/2053. It's the Independent Commission for the Remuneration of Public Office Bearers, and that's established under that Act. So what happens is the process starts with the Independent Commission. It then goes to the President, who makes a determination, and then under subsection B, it is then approved by the National Assembly in terms of section 2C. And then section 2C simply sets out the procedure that must be followed by the National Assembly when it approves the determination made by the President on the recommendation of the Independent Commission. So what we know then is that the current service conditions predate the 2019 amendment. These were the conditions that were determined under the unamended provision prior to the introduction of section 2, subsection 2. But it's crucial to just remember that there is an error in the founding affidavit. But that error is addressed in the answering affidavit. It's also addressed in the heads of argument. But I was surprised to hear that it was repeated yesterday. So what we know then is that the service condition...
Forgive me. On the case pleaded by the applicant, does anything turn on her reliance on the pre-amendment?
Yes, only in this sense, because you remember that when your Lordship was debating what is the status of the conditions of service, the attempt was made to equate them to legislation. So in that sense, they are not legislation. What they are is terms of employment equivalent to a contract. Because what my learned friend tried to suggest was that because it was an act of Parliament, or let's say an action of Parliament, it was enjoying the same status as an act of Parliament. That's a mistaken submission. The Constitution doesn't set the salary, benefits, or allowances. national legislation also doesn't do so. And then Parliament determined those terms and conditions that we have. And under the new Act, the function is now allocated to the President. So if one made the error of equating that determination to legislation, you would then have the oddity of the President drafting the law. So that's the first question to be clarified, is that the service conditions are not legislation. They also are not a provision in the Constitution. What they are is a subsidiary action that has the force of contract. And this will be important when we deal with PAJA, because there is also a lot of fallacy that is made in relation to PAJA. So much then for the status of the conditions of service. They have no force of the Constitution, no force of statute, but only force of contract. What about the status of the public protector? This has been dealt with before by the Western Cape Division. We've in fact found the two authorities. Remember that yesterday there was constant reference to the public protector as an employee who is entitled to rely on Section 23 of the Constitution and the BCEA. There are two judgments of the Western Cape Division, full bench judgments. Perhaps I should just hand them up so that I think they are in fact on case lines. That might be better to just take your lordship to the case line references. The first one is the...
Would that be under authorities?
Sorry, my lord.
Would that be under authorities?
Under authorities, yes. Under, it's item 20, 2192. So 20/2192.
Yes.
So if you are in that judgment, your lordship should look at paragraph 78.
Is that Millennium Waste?
No, my lord.
Which one?
It's the Public Protector of SA versus the Speaker of the National Assembly. So it's under item 20/2192.
Yes.
So if you are there, my lord, may I ask that you look at paragraph 78, which is at 20/2213.
Right.
So if you look at paragraph 78, the judgment makes it clear Advocate Mkhwebane clearly does not enjoy the status of an employee. Rather, she is a constitutional office bearer, and Advocate Mkhwebane's right to institute the now new rescission application is in no possible way compromised by the continuation of the parliamentary impeachment process. So at that point, she was trying to stop the parliamentary impeachment process, and the issue of whether she was an employee or not arose. But it's clearly decided there that she's not an employee. And then there is an earlier judgment, which is also a full bench judgment of the Western Cape Division, also called Public Protector versus Speaker of the National Assembly. We attached this to item 20/2231. So 20/2231. And it was also another attempt at stopping the impeachment process. And the relevant paragraph there is paragraph 90, which is at item 20/2289. And so what's important about that paragraph is that it just affirms the history I've just given about the amendment of 2019. So towards the end of paragraph 90, the following appears. It records the submission made by the respondents. The respondents also contended that the applicant and the 16th respondent's reliance on the Public Protector Act was wholly misplaced, and pointed out that following an amendment to the Determination of Remuneration of Office Bearers of Independent Constitutional Laws Amendment Act 22 of 2014 with effect from 1 April 2019, none of the references in the Public Protector Act as an employee and her terms of conditions of employment remain. So the first judgment makes it clear that she is not an employee. The second judgment contextualizes that it's true that before 2019 there was the odd reference to the conditions of employment. That was struck out and replaced by section 2, subsection 2 of the final act. So two things then are clear from the analysis I've just given. The first is that the conditions of service do not have the force of a statute or the constitution. They only have a contractual force. The second is that the public protector is not an employee. She is an independent holder of a constitutional office. So then, to then come to the decision itself, that is the subject of the controversy. It's necessary to just again correct the incorrect submissions that were made yesterday about what the decision was and what were the reasons given at the time. So what we know, and I will ask your Lordship to have regard to item 26, which is the Rule 53 record. So what we know is that the starting point is a request, and the request is at item 26, page 833. So it's all under the record. So item 26/833. So what we know on the facts is that there is a request dated the 6th of December 2023 by Ms. Mkhwebane. In paragraph 2 of that request, she makes the following assertions. Paragraph 2.1, she says, our client vacated office on or about 12 September 2023, 1 month before the expiry of her term of office. That's the first point that she makes. The second point is 2.2, where she says, as you are aware, and in terms of our client's conditions of service, and in particular clause thereof, our client is entitled to payment of a gratuity. So we know for sure here that what she says is the basis for a claim is a vacation of office prior to the expiry of a term of office. And number two, the legal basis that she asserts is the conditions of service. Now, that never changes at all in the exchange until the decision is made, and the decision is a couple of pages after 833. It is at 26.844, and that's the response. Now, might I just mention that when I say decision, I do so without prejudice to the Parliament's rights to argue that it is not a decision. But we've certainly taken the view that a decision was taken. So at item 26/844, there is then a response to the request. So to just recap, the request says I've vacated my office before the lapse of my term. Number 2, the sole basis for the payment is the conditions of service. What is then stated to her in response starts at paragraph 2.1. Number 1, your client was removed as the public protector via the adoption of a resolution by the National Assembly, and the resolution was confirmed and executed by the President. Your client did not vacate the office of her own volition. So paragraph 2.1 already tells her that there is a resolution of the National Assembly and there is a confirmation and execution of that resolution by the President. 2 additional facts. And then 2.2, the conditions of service only authorize the payment of a gratuity when the incumbent has vacated office, not when the incumbent is removed from office. Paragraph 2.3, apart from the conditions of service, there is no other authority that our client is aware of, including the Constitution as well as the Public Protector Act, which permits our client to consider paying your client a gratuity under circumstances where an incumbent is removed from office. And then the last paragraph, in the circumstances, our client regrets to inform your client that there is no enabling provision in the determination of the conditions of service of a public protector, which authorizes the payment of a gratuity as provided for in paragraph 3.1 of the conditions of service of the public protector, if his or her term of office ends by virtue of his or her removal by the President in terms of section 194 of the Constitution. So she is told that if you are removed pursuant to section 194 of the Constitution, which is a removal for misconduct, removal for incapacity, and if that removal is based on a resolution by the National Assembly confirmed by the President, you are not entitled to a gratuity. It's in the letter, all of it is in the letter. They are then, so it's then clear then that the accusation that was repeatedly made with a lot of reckless abandon yesterday, that new reasons have been inserted, is unfounded. So to complete the picture here, there are 2 additional facts that are mentioned in the letter. One is a resolution by the National Assembly. The second is the decision by the President under section 194 of the Constitution. We know where those are in the record as well, because they are encapsulated in the decision of the 12th of February 2024. So to start with the resolution of the National Assembly, that is at page 26.414.
26?
Stroke 414.
Yes.
And if you turn the page to 26416, and it first records signed by the Secretary of Parliament. So at the end of that page, it says, question agreed to, recommendation for removal of Advocate Mkhwebane from the office of Public Protector in terms of section 194(1)(c) of the Constitution, accordingly agreed to. So that's the resolution passed by Parliament. Then, that's the first document. It's clear Parliament is acting under section 194. The second document referred to in the letter of the 12th is the decision by the President. They say, Parliament has resolved to remove you under section 194. The President has executed that decision, also under 194. That you will find at 26/417. And the last paragraph is the relevant one, which says, I therefore, that's President Ramaphosa then says, I therefore hereby inform you that you are hereby removed from the office of the Public Protector in terms of section 194, 3B of the Constitution on the grounds of misconduct and incompetence. And then he attaches the Presidential Act. But the Presidential Act is basically the same document just signed by him. So the two documents that are then encapsulated in the letter of the 12th of February 2024 could not have created any confusion that the reason for the disentitlement to the gratuity is a removal under Section 194 of the Constitution and a passage of the resolution by the Parliament and the endorsement thereof by the President. They all make it abundantly clear that the reason is removal, and they also set out the cause of the removal, which is Section 194 of the Constitution. So on the facts, that is what transpired. And in fact, I noticed when this was read that actually the other passages were just not read yesterday. So can we then go to whether or not she has established an entitlement to the conditions of service, now that we know that the letter she wrote to the Public Protector, I mean, I know she complains at some point that the Public Protector has no power, but she is the one who asked for gratuity from the Public Protector. So we know that the only basis that she claimed she wanted payment was clause 3 of the conditions of service. She never said she wanted payment under any other basis. The rest appears in the pleadings, but it does not appear in the letter that she wrote upon which the decision was then made. So what about whether she has made out a case under the conditions of service themselves? Now that turns on the interpretation of the conditions of service. In other words, can she prove a clear right to payment of a gratuity under the conditions of service, which is what she is obliged to do. The conditions of service, they also appear in different parts, but I'm using item 18, page 39. Item 18, stroke 39. So they deal with 8 items, and gratuity is a third item. So we've got to then construe that properly. So we submit that there are 4 textual indicators there that make it clear that there is no entitlement to a gratuity where the Public Protector is removed on account of misconduct and incompetence as envisaged in Section 194 of the Constitution. And in fact, in her own letter, she incorrectly said, I vacated office prior to the lapse of my term of office. So which you can't vacate before the lapse of the term, except for the 3 factors I will outline now. So the first indicator is, of course, the heading. The heading is gratuity. It's not salary. It's not medical benefit. It's not an allowance. It's a gratuity. It's a genus on its own. The reason why that is important is because of the cases that we rely upon at paragraph 7.1 to 7.4 of our heads of argument. Your Lordship knows the law on this. A heading must be taken into account in construing the meaning of a provision. So When it says gratuity, that is not inserted there for gratuitous reasons. It's inserted because it has a consequence for meaning. The first case is Welch. My learned friend took no issue with the case of Welch. The only point he made was that it is a tax case and therefore inapplicable. But it may be a tax case, but it is explaining or explicating what gratuity means. And it makes it clear that when something is paid as a gratuity, it's motivated by pure liberality and not in expectation of any quid pro quo of whatever kind. And then in 7.2,
Mr. Kholeka, I just wanted to debate Welsh with you. I understood the fundamental claim that is made by your clients to be that Welsh is an authority for the proposition that there is never a legal basis to a gratuity.
No, we say that when you see the heading in item 3, gratuity, that should give you an indicator that a gratuity is not something you can demand as of right.
Yes, no, I understand that, but in your submissions, you seek to make a more fundamental assertion, i.e., that there is never a legal basis to a gratuity.
Yes.
Now, the issue of liberality and so forth, that is more of an explanation of the statement, i.e., in law you can't claim a gratuity as a matter of law, and the reason for that is because the nature of a gratuity is liberality of conduct on the part of the person.
Yes, your Lordship has got it correct.
But I do not read Welsh to make that statement.
Yes. Your Lordship should guide me about precisely where the concerns are.
Yes, well, on the point of there in law never being a legal basis to a gratuity.
Oh yes, no. I think I should then state the proposition less forcefully and simply rest with one baseline, which is there is no entitlement. You cannot go to court and say, I am forcing the employer to pay me a gratuity, which is not the same thing as saying a statute may not create a gratuity that is enforceable, or an employer themselves may not create conditions of service where a gratuity is enforceable.
Yes, but even that proposition seems to be incorrect. For example, when you have regard to the following decision.
Quantum.
No, not quantum. Quantum, in my view, is a misreading of Welsh.
Yes. Let me just find Welsh.
I do need to draw attention to.
One 1812. Yes. Yes. Welsh is at item 20. 1813.
Yeah, with Welsh, the issue as to the nature of a gratuity that appears in paragraph 21, I believe.
31.
31. But Welsh didn't go any further. Quite apart from the fact that that was not an issue for determination in that case.
Well, my Lord, could I just ask your Lordship to go to item 20, 1823.
Item 20.
Yes, 1823. So it's paragraph 30 and 31.
Yes.
So paragraph 30 says, if one were to scour the distinctions to find a single word apt to convey that the disposition should be motivated by pure liberality and not in expectation of any quid pro quo of whatever kind, one would not find a better or more appropriate word than gratuitous. The shorter Oxford English Dictionary gives the following meaning to the word, that is gratuitous: freely bestowed or obtained, granted without claim or merit, costing nothing to the recipient, free. 2, done, made, adopted, or assumed, without any good grounds or reason, uncalled for, unjustifiable. And then paragraph 34 continues, the ordinary meaning of that word, and that's still talking about gratuitous, in the context of making a disposition includes, I suggest, without obligation, for no return, without any quid pro quo, being given or expected. None of these meanings is incompatible with the coexistence of a motive for pure liberality or disinterested benevolence. So it seems that they assert that it's without obligation,
Yes.
creating no rights, no entitlements.
Quite so. I do not take issue with what the court construed to be what constitutes a gratuity.
Yes.
The issue that I wish to debate with you is the proposition that there can't be a legal basis to whether or not a person gets a gratuity. The case that I want to refer you to is the decision in Government Employees Pension Fund, Provincial Government of Gauteng, against Buitendag, Buitendag and others. That's
Is that in one of the cited authorities?
I don't believe I've seen that in your authorities. It's a 2007 decision. The issue there was the following.
I don't think it is
Right.
included. We'll have to look at it.
Yes, but more narrowly, the issue there was that the deceased was employed by the provincial government.
Yes.
In terms of the rules passed, pension fund rules passed in terms of the Government Employees Pension Law 1996, if you worked for more than 10 years, you became entitled to a gratuity on your death. Now, you needed to have advised the fund of your beneficiaries, so you fill in the form. What will then happen is the board then had a discretion as to which beneficiaries it would, as it were, give the gratuity to. So the point here is that the beneficiaries went to court asserting that they were not listed on the form. Some other beneficiaries were listed. They were not listed on the form, and they should have been listed because they had an entitlement to a gratuity. So now the case seems to be against your fundamental submission that there can never be a legal basis to a gratuity because the nature of a gratuity is
Pure liberality. Yes. I submit the following. I think I remember that judgment, and in fact, I don't know whether it's the one that ultimately turned on administrative action, whether it's the SCA judgment that turned on whether the payment by the GEPF was an administrative act or not. But I seem to remember coming across the judgment.
Yeah, this one didn't deal with the issue of the nature of the conduct.
Decision by the GEPF.
Yeah.
Nevertheless,
there are quite a number of those.
Yes. Nevertheless, I will consider that. My Lord, I make two submissions. The first submission is that there is a difference in relation to a surviving spouse or a child. So their rights may be immediately enforceable. In fact, this is a submission I will make in relation to this particular clause we are dealing with. So the child would have a right, but the right of that child is dependent on whether or not the principal member had a right. In other words, the principal beneficiary to the scheme had a right. But if you did have a right, that right passes on. So that factor is a crucial distinguishing factor. But it still doesn't answer the question as to whether or not the principal member has a right vis-a-vis the scheme to a gratuity.
In this instance, the principal member had a right,
yes,
because the rule passed pursuant to the legislation made provision
for
that if you are employed by the government, in this instance the provincial government, for 10 years, on your death, you become entitled to, you'll be dead.
You become eligible or entitled.
Sort of a gratuity will be due,
yes,
as a result of you having been employed for more than 10 years.
Yes. Yes, no, that's the second proposition. So the second proposition, first proposition, the right of a secondary member, let's call the child a secondary member, is dependent on the right of a principal member. And if a principal member is entitled, the secondary member is entitled. Now, as to whether or not a principal member is entitled, that is a matter of the construction of the instrument. And the construction of the instrument takes into account whether or not it is an obligatory payment or a gratuitous payment. It is true, we submit, that there are gratuitous payments that are made obligatory, and that is the discretion of the employer. So the employer could say, when it is drafting its rules, in our rules, we're going to make a gratuity obligatory, but it has a discretion to do that. But in the absence of that entitlement having been conferred by the employer in its rules, we have no right to a gratuity.
Yeah, that would be so.
Yes.
But again, the more fundamental issue which the court is debating with you is, in your head, the making of a categorical statement.
Yes,
which seems not to accord with at least this one decision.
No, the categorical statement, my lord, is defensible depending on what stage do you say the discretion is to be exercised. Once you've exercised your discretion to insert in the rules an entitlement for a gratuity, you have exercised that. The question is, absent that discretion, is there a right under the common law to a gratuity or not?
Now, that is entirely different. Quite so.
Oh, yes. No, then I think we were debating the same point but coming from different angles. So the question is that absent a rule which is discretionary, can you make a claim for a gratuity? For instance, under the common law, there is an entitlement to a wage when service has been rendered. And that came after many, many arduous fights flowing from the law of master and servants, which did not always require remuneration. And then the common law developed that even if you have no contract of employment, no statute, but when you are rendering a service, there is a right to payment. In other words, that's not dependent on the discretion of an employer writing it into a rule.
Yeah. Well, the court will accept as a correct statement of the law
Yes.
that absent a rule, one can't claim a gratuity.
Precisely, yes. So this is the point that we've been trying to pursue in these four judgments. If I may then proceed, Quantum Foods is the next judgment at paragraph 7.2. It's an interesting judgment because what had happened there was that there had been a determination of a minimum wage. And the question was, what are the components that go into the minimum wage? Some employers were including into the minimum wage the gratuity payments, that they form part of that wage. And so when you are determining whether or not they have met the wage, let us say it's 4,000 rands, it is inclusive of the gratuity payments.
Except in quantum, what was included was a bonus, but
Yes.
the court construed
Yes.
bonus to be akin to a gratuity.
A gratuitous payment. And then it relied on Welsh. But the principal point is this. If there is a payment that imposes no obligation and the employer disingenuously tries to insert it into the remuneration, the court decoupled that and then said this portion, this quote-unquote bonus portion, is not part of the minimum wage. And the reason they set out there, we've quoted it at paragraph 7.2. And I don't need to take your Lordship through this because your Lordship from the exchange is familiar with that passage. What's crucial, though, about quantum is that it's outside of the tax authorities. It's in proper employment. Yes. And it's the same point made in S versus Commissioner of Taxes. That's the Zimbabwe case at the time, Southern Rhodesia. And the same point made in 7.4.
Well, except as the Commissioner, I consider that to be a misreading of what the appellate division said, and you de Villiers. And I believe that the respondents misconstrued de Villiers on the issue as advanced in the submissions. Because what the respondents say, your clients, what they say is that de Villiers is an authority for that fundamental statement, in the way that I had put it. But that was not an issue for decision. Do you recall that in de Villiers, it was an instance of the Attorney General whose term had come to an end.
Yes.
And an amount was paid. He had, 136 days leave due to him. Because his office had been determined, he was paid an amount, and the receiver wanted his pound of flesh. The Attorney General said, well, that is not taxable because it was payment in solatium. The court disagreed and said the receiver had to have his due. Now, in the context of the submissions made as to gratuity in the context of whether or not it could be claimed. There were two judgments.
Yes, there is
by Vessels, J.A. and
Kalous, yes.
De Villiers agreed but did not make any statement. In the context of the case made in the heads, I believe that it's a misreading of what, in fact, Vessels said. Because Vessels said, in part, that it made no difference whether the money paid to the Attorney General was a gratuity or a moral obligation or as a contractual right.
Yes.
So it didn't matter. Now, on that statement, this decision can't support your position in a way formulated in the head.
Yes. Well, my Lord, the submission made at 7.4 seems to accord with your Lordship's reading, because if I can take you to that passage.
Yeah.
The submission that is made there is similarly in de Villiers versus Commissioner of Inland Revenue. The appellate division distinguished between a gratuity and payments made as a matter of contractual rights.
Yes, but that's precisely what they didn't do.
Yes.
The appellate division wasn't making that determination. It wasn't drawing a distinction. It said it doesn't matter what label you place this payment under, you still have to pay tax.
Yes. Well, yes, my lord, I see your lordship's point. I mean, there is, though, a clear statement in the passage, which is at 232, that seems to distinguish between payments made as a gratuity to those made as a moral obligation, and then those made as a contractual right. And then I take your lordship's point that they said it doesn't matter if it is made as a gratuity, as a moral obligation, or out of contractual rights. So the point we were trying to make was that those three categories were set out as distinct from each other.
Yes.
And then, so that was de Villiers, and then S versus Commissioner of Taxes, that judgment you will find, again, your lordship is familiar with it, at 1262, but the relevant passage is 1271. And particularly at B to E.
Yes, it references de Villiers, but misreads it, because yes, it suggests that de Villiers decided the issue when in fact that wasn't the determination in de Villiers.
Yes, my lord. What it does say is compatible with our submission. But if your lordship says, well, let's go back to de Villiers and see what it found, the submission we will make on de Villiers is that when they were determining the issue, they distinguished between the three categories of payments. In other words, they did not regard a gratuity as part of the contract.
No, it can't be. They didn't distinguish amongst the three categories. They said it doesn't matter. The label doesn't matter.
Yes.
Because if the label doesn't matter, then one can't have a debate as to what heading a particular aspect will fall under.
Yes, no, I've taken that point. I still simply make the more modest point, is that in that very statement, it classifies these into three. And then it says they are actually irrelevant for the case we have to decide.
Yes. I suppose at best for you, what you could say about de Villiers is that it recognizes an instance of a gratuity, an instance of
moral obligation,
and
then contractual obligation.
I think that is the best that you could say.
Yes.
De Villiers recognized without deciding any of that.
Yes, and that is enough for the distinction I am trying to draw, because I'm trying to draw a different distinction to whether or not the money in the hands of de Villiers would have been taxable. I'm trying to simply draw the distinction that conceptually the three are different, and that court records them as conceptually distinct. Yes. And that's the only finding I will ask your lordship to make, even in relation to S versus Commissioner of Taxes. It's the conceptual distinction. And you will see this at A to G, which is at page 464 of the judgment, and page 20/1271. So to come back then to the point we make about the conditions, is that when you see the word gratuity, absent a rule, there is no obligation. And the four judgments that we have cited, Welsh, Quantum, Commissioner of Taxes, let's put aside de Villiers for a moment. At least the three judgments recognize that absent a rule, there is no obligation. And then de Villiers is supportive only in the limited sense of appreciating the conceptual distinction among those three terms. And the terms that are important for our purposes is contractual and gratuitous. So that's the first indicator. It's the heading and the meaning of a gratuity under the common law. Now, of course, the legislature could depart from the common law. But if it wants to do so, it must be clear or be apparent from necessary inference that the intention was to depart from the common law. The second item here that is relevant is 3.1 itself, which is the condition of the payment of a gratuity. It's different from the nature of a gratuity, but the condition of the payment. And the condition of the payment of the gratuity is vacation of office. Now, again, this needs some explication, the idea of a vacation of office. The starting point is section 193 of the Constitution. So, Your Lordship has seen the provision of the Constitution from the case line references. So under section 183, which you will find at item 20, 1974. Yes. The Public Protector is appointed for a non-renewable period of 7 years. So after 7 years, they vacate office. So that much is clear. It's a constitutionally prescribed term limit. Then there is another category of a vacation of office, which is recognized in the Public Protector Act. So if I can ask Your Lordship to go to, the Act itself appears at item 20, 2052. So we know, number one, on vacation of office. Vacation of office, you've completed your term under section 193 of the Constitution. And then the second, which actually vacation of office, is in the Act itself at section 2, subsection 3. And that is at page 20, stroke 2055. And that sets out two instances of vacation of office. So instance number one is regulated by section 193 of the Constitution, lapse of your term of office. Instance number two is regulated by the statute, which says under section 2, subsection 3, the National Assembly, or if Parliament is not in session, the committee may allow a public protector to vacate his or her office, A, on account of continued ill health. So ill health, as Your Lordship knows, is incapacity. So if the public protector is too ill to work, they may ask the National Assembly to allow them to vacate office before the lapse of the prescribed term for the vacation of office. So that's the second category of the vacation. It's at the discretion of the National Assembly upon the application by the Public Protector. And then number two, at his or her request, provided that such request shall be addressed to the National Assembly or to the committee as the case may be, at least 3 calendar months prior to the date on which he or she wishes to vacate office. And or the committee as the case may be allows a shorter period in a specific case. So this is a resignation. So So we now have 3 constitutionally and statutorily recognized methods of vacating office. Your term ends under Section 193, or you are ill, in which event the committee may allow you to leave, or you resign, provided you've given a 3 months notice to the resignation, you may be allowed. Then there is a 4th category of vacation, which is also referred to in the instrument itself, which is 18/39, paragraph 3.2 of the instrument, which is vacation by death.
Instrument being what?
The conditions of
the
service.
act.
Yes.
Oh,
No, the
see.
conditions of service.
Now,
Yes.
the conditions. Right, 3.2.
Which is vacation by death. Now, that's not a vacation, it's a deemed vacation, but it's nevertheless vacation by death. And you will see that it's a deemed vacation from item 3.2 itself. And I'll come back to the arguments made about the use of the word shall in that section, because it's again a product of a misinterpretation. 3.2 says, the surviving spouse of the public protector who died before his or her term of office as public protector has expired shall be paid an amount equal to the amount of the gratuity, which would have, in terms of paragraph 3.1, have been payable to the public protector had she or he not died, but on the date of his or her death, vacated his or her office in terms of that paragraph. So, although you have not completed your term, but you are dead, and that is then deemed as a vacation of office. So that the 4 categories of vacation. So there is no other category that is recognized in the Constitution, in the Act, or in the instrument. There are only 4. So to recap what they are, it's vacation by completion of the office under Section 193 of the Constitution, vacation at the instance of Parliament on account of ill health or incapacity, vacation by resignation, provided that 3-month notice is given, and vacation by death. So we then come back to clause 3.1. The condition for the payment is vacation. And vacation is a term that is recognized in law. What is clear about this idea of the vacation of office is that it is different from removal. And removal is not included in vacation. And this was not an error, because vacation was dealt with in the Act. It was dealt with in the rules. And of course it is in the Constitution, because the term is 7 years, non-renewable. So it's not an error, it's not an omission. Vacation is a specific, those are the 4 categories of vacation. Now, removal is completely different, because it is to be found in Section 194 of the Constitution. Sorry, yes. I said 193. It's 183 of which is the tenure. Removal is Section 194, which you will find at item 20/1977. So, which you may be removed on the ground of misconduct, incapacity, or incompetence, or there may be a finding to that effect by a committee of the National Assembly, and C, the adoption by the Assembly of a resolution calling for that person's removal from office. Now, we know that if the issue is incapacity, it's dealt with in the Act, Section 2, subsection 2, as a vacation, a category of vacation of office. It's legislated. The categories that are not legislated is misconduct and incompetence. Not legislated, not provided for anywhere. And the Act could have made this plain because when it was dealing with vacation, which you will see at item 20/2055, item 3, section 2, subsection 3, it only chose ill health. That's the only category it chose, ill health. So this is all a deliberate drafting policy by the government. By Parliament. We then look at vacation. Know that vacation has a distinct meaning, which is different from the removal from office on the grounds that I've articulated to your Lordship. And we know that even in removal, the legislature has done this job for us because it's lifted out one category, which is ill health, and dealt with it as a subset of vacation. So that's the second indicator from the grounds of vacation, the grounds of payment of a gratuity, which is vacation from office, and what that means. And then you have the third indicator coming from item 3.2. Now, this does not create an entitlement to the primary holder of the office, not an entitlement to the public protector. It's an entitlement to the surviving spouse. It says the surviving spouse of the public protector who died before his or her term of office as a public protector has expired, right, shall be paid an amount equal to the amount of the gratuity which would, in terms of paragraph 3.1, have been payable to the public protector had he or she not died, but on the date of his or her death vacated his or her office in terms of that paragraph. So this is what we call vacation by death because it uses the term vacate. But the shall is not referring to the public protector. It is referring to the surviving spouse. What it is simply saying is that the surviving spouse has a right to whatever the public protector would have been entitled to. But to know whether the public protector is entitled, you go to in terms of paragraph 3.1 above, which would have been payable in terms of paragraph 3.1 above. So there is no substantive self-standing entitlement flowing from clause 3.2. It in fact reinforces the submission I made to your Lordship that the departure point is clause 3.1, which tells you the conditions under which gratuity may be considered. So in order for you to know, should I pay the public protector, you always go to gratuity, you always go to 3.1. And again, what it does do is that it again reinforces the point about death being a category of vacation. So it's a deemed vacation, which is the fourth of my four categories of vacation. And then it obviously sets out that formula. Then the fourth textual indicator is, you will find at page 18/41, which is item 8.11, which deals with transport and subsistence allowance. That's a different category of benefits. But the important point here is that 8.11 distinguishes in terms between removal from office, vacation of his or her office, the death of the public protector. Now, of the protector is a deemed remover, is a deemed vacation, but it's a special category. So it's not tautologous to use that. And then the vacation of his or her office, we know that there is vacation because the term has ended. And there are also two categories of vacation, which is incapacity and resignation. But then there's removal from office, which is a category apart. And it's recognized in the instrument itself, which is 8.11, Roman figure 1. Now, my learned friend knew yesterday that this was a difficulty for him. And when he was asked, why did the legislature, why did the instrument say removal from office and then vacation from office, if vacation is such a capacious term that it incorporates removal? And then he said it was because it was tautologous. The problem, of course, is that the law contains a presumption against interpreting statutes to produce tautology. Yes. We have found the judgment on the point, which is item 20/2176. And the judgment is called African Products.
20, forgive me, 20, what page number?
2176, my lord.
2176.
Yes, ma'am.
Thank you.
So the judgment is African Products versus AIG South Africa Limited. The relevant paragraph is 12 and 13. So what it makes clear yes, paragraph 13 actually, which is more direct on the issue of tautology. It says, since the words, and those were words I think in an insurance contract, yes, since the words unforeseen and sudden are joined by the conjunctive and the physical damage to the cables must have been both unforeseen and sudden. And because the two words may, depending on the context, bear the same meaning, and then look at what happens next. They must each be given a meaning that will avoid tautology or superfluity. In Wellworth's Bazaars versus Chandeliers, LTD and others, this court quoted with approval the following passage from the decision of the Privy Council. In Ditcher versus, it is a good general rule in jurisprudence that one who reads a legal document, whether public or private, should not be prompt to ascribe, should not without necessity or some sound reason impute to its language tautology or superfluity, and should be rather at the outset inclined to suppose every word intended to have some effect or to be of some use. A court should thus be slow to conclude that words in a single document are tautologous or superfluous. So once you see removal from office as a standalone phrase, the rule is it is not intended to be tautologous. It's intended to contain a self-standing meaning. And here in context, we say you are required to obviously bear in mind words from different aspects of the same instrument when you are interpreting the instrument, because interpretation is a composite task. So to sum up then, the fourth textual indicator that removal is not included in vacation, and where vacation overlapped with removal, it was dealt with in the legislation. The fact that the instrument itself separated removal is a clear, we submit with respect, coherent and logical indication that removals for misconduct and incompetence were not intended to clothe the removed person with any entitlement to a gratuity. Now, those four textual indicators have not been meaningfully addressed by our learned friends. There was a lot of hand-waving and no jurisprudential engagement. So, in sum, on the text of the instrument, they are not entitled to a gratuity. On the text of the instrument that they themselves, on the 6th of December 2023, claimed was a basis for their entitlement, they have not shown their entitlement. And so when the Public Protector responded to them on the 12th of February 2024 and said, I cannot find any legal basis that would authorize me to make a payment, she was correct, I'm afraid. What then remains? And so the claims, I mean, there were a lot of emotional statements made yesterday that it was punishment, it was a reflection of bias, etc., etc. They are all irrelevant because this is a dispassionate analysis of whether the instrument that she relies on confers an entitlement to a gratuity. And here, my Lord, I need to state one more thing before I depart from this, which is the debate whether in general a gratuity confers an entitlement or not is not dispositive of this topic, because we have considered from the onset that it is a matter of the construction of the instrument in question. Some instruments may entitle one, others may not entitle one, but the instrument that has been cited here as the basis simply does not confer the right in question. And again, without prejudice to what Mr. Mutau is about to say, that is why it is unhelpful to use the judge's conditions of service to resolve this case. There is a case that will come, I don't know if it will or it will not, of a removed judge or an impeached judge. That case must be dealt with in the future. It's not part of this dispute today. Now, if the conditions of service, as we have painstakingly analyzed them, do not confer a right to a gratuity in respect of a public protector who has been removed from his conduct and incompetence, as I have shown, what else does the applicant say is the basis for the entitlement? Now, Your Lordship, I've shown that at the time of the application, the only instrument that was cited were the conditions of service. Obviously, the case has expanded quite significantly, both in the pleadings as well as in the heads of argument. We don't begrudge them that, because a case does evolve. And it may not be an excuse for us to say that's not what you requested if they come along and say, I can show that under the statute I have a right. And they must be paid.
Mr. Nkobi and Gugatori, just from a logical point of view, at least in the mind of the court, before you address the court on what the respondents say are the applicant's other basis for the entitlement. It seems to me that it makes logical sense for you to address the court on one of the alternatives relief, namely that clause 3 is contrary to public morals, is a breach of the Constitution, and is a breach of the rule of law. That way, you would have, in a single session, as it were, you would have dealt with that issue, unless one of your juniors was going to deal with that aspect.
Well, actually, it's more elevated than that. It's Mr. Mutau who will deal with that. Yes.
I'm not suggesting that Mr. Mutau is a junior. Right, but
I'm happy to then deal with the BCEA.
All right, yes.
Because
yes.
that follows after the section that Mr. Mutau will deal with.
Yes, all right. Well, then we will leave that for Mr. Mutau
to address.
To deal with.
My Lord, then, the BCEA itself is at, again, the whole statute is here to copied. The BCEA is at 1856. That's sorry, item 20, 1856. That's where the Act appears. Firstly, if I can ask you, Lordship.
Forgive me. Before you start your address, what the applicant has pleaded in relation to the BCEA is the following, that section 32(3)(b) doesn't say that she's not entitled to a gratuity. That's one aspect. Second aspect is that the condition of service embodies the employment contract mentioned in the BCEA. I've paraphrased that part. And the third aspect relating to the BCEA is that the decision was a breach of the BCEA. So when you make your address, if you could comprehend those three aspects.
Yes. Thank you, my Lord. I'm indebted to the Lordship's guidance. So the first question on the BCEA is whether it applies or not to the relationship, because it can't ground a cause of action if it's of no application. And you see at item 20, stroke 1864, section 3. It says this act applies to all employees and employers except the excluded categories. So the first issue is the public protector has to prove that she is an employee. Now, we know that from the analysis I did at the outset, the Public Protector Act was amended in 2019 to remove references in the old section 2, subsection 2 of the Public Protector Act. References to employment. And we also know that the two judgments that have come from the Western Cape High Court, where she had asserted that she's an employee, have made it clear that she's not an employee. But we also know from the scheme of the Constitution that the holder of the office of the Public Protector is an independent constitutional office bearer that is responsible for investigation and reporting on maladministration under section 181 of the Constitution. She simply cannot be an employee. She is meant to oversee the state, which on her articulation is her employer. So because she cannot establish that she is an employee, the entire cause of action that is founded on the BCEA must be rejected. It would be incongruent if your lordship found that the public protector is an employee. It would be utterly destructive of the constitutional scheme, because it would mean that the independent holder of an office established by Chapter 9 of the Constitution is somehow subservient to the state. And that would be destructive of that office and the role that it plays.
Now, on the assumption that the court makes precisely that very finding, what are your submissions in relation to the issues as pleaded?
Yes, I want to then go to the alternative submission. The substantive basis for the is section 32, which your lordship will find at item 20/1877. Section 32(1) says an employer must pay to an employee any remuneration that is paid in money. And then section 32, subsection 3, an employer must pay remuneration not later than 7 days after the completion of the period for which the remuneration is payable, or the termination of the contract of employment. So in this instance, we know that she has been removed. But you then go back to what does remuneration mean? Because it's remuneration that must be paid, not any other thing. So you find the definition at item 20/1863. And it says remuneration means any payment in money or in kind, or both in money and in kind, made or owing to any person in return for that person working for any other person. So it is your classic salary, money in exchange of services. It is not inclusive of gratuities, because unless provided for in a rule, gratuities are not part of a salary or a remuneration. And this, in fact, is distinguishable completely even from Section 2 of the Public Protector Act.
Yes. Before you deal with Section 2, you will recall Mr. Mpofu making the submission that that a gratuity must be construed to fall under the heading of benefit, which forms part of the remuneration.
Yes. Well, firstly, that is not the case under the definition of remuneration of the BCEA, because, as your lordship pointed out, we've now also found the determination made in Section 35. So if you go to Section 35, because we're trying to work out how do I calculate remuneration and a wage, and you'll see that it's at item 20/1879, and particularly 35 subsection 5. The minister may, by notice in the Gazette, after consultation with the Commission and deadlock, determine whether a particular category of payment, whether in money or kind, forms part of an employee's remuneration for the purposes of any calculation made in terms of this Act. And we couldn't see a later determination than 2003. But the 2003 determination is at item 20/2174. And item 2 sub C excludes gratuities. Now, I know that when the item was debated yesterday, Mr. Mpofu attempted to reduce gratuity into a tip. But it is a fallacious argument because it converts the genus by reference to the example. Whereas the real issue is that the gratuity is excluded in whatever guise that it emerges. So it does not help to be dismissive on the part of Mr. Mpofu when he's confronted with a difficult question.
Sorry to interrupt, but I never equated gratuity to a tip. It's the court that did sought to dispel that.
I mean, it's actually worse when he is now accusing the court of reducing it into a tip.
Yes, you may continue,
Yes,
Mr.
thank you, my lord. I'm indebted to the court. So we then have three arguments about the BCEA. Argument number one is that the BCEA is inapplicable. Argument number two is that the definition of remuneration under Section 32 and the section on definitions does not include gratuities. Argument number three, the BCEA itself confers the power on the minister to determine what's included and excluded, and that determination has been made. Gratuities are excluded. So the declaration, therefore, that is based on the BCEA is a non-starter. My lord, the time is 11:08. I'm just not sure whether I've not exceeded your lordship's patience.
No, not at all. Have you concluded your address in relation to the
BCEA?
BCEA?
Indeed.
So
I've
you will
concluded.
then revert to the aspect that you wish to
Yes. Yes.
address the court on, i.e., other basis for the entitlement.
Indeed. So I needed to go back then. So what I had done is a full analysis, hopefully, a helpful one, of the conditions of service.
Forgive me. Are you about to start then that new aspect?
Yes.
Other basis?
Yes.
Right. Well, what the court will do, we'll take its break now.
Yes,
And,
Your Lordship, please.
we will resume at 11:20.
Indeed.
The court will rise.
That was good for us.
That's what I'm saying. No more. I'm not saying from where.
Oh, you just say it.
I'm not talking about the source.
I
causes of action. So they are all over the place, literally all over the place. So I'm trying to address them in a systematic way that would be helpful to the court. Under the Constitution, there is a couple of causes of action that are referred to. Firstly, there is Section 9 of the Constitution. And it might be that the best place to deal with it is to address it under discrimination, which is a ground of review, bias code discrimination. So at this point, I will not address it. And then the second one is fair labor practices. Now, the problem, of course, with fair labor practices is that under the principle of subsidiarity, it is not directly applicable. It is only applicable through national legislation, which could either be the LRA or the BCEA. And the legislation that has been chosen to codify Section 23 by the applicant is the BCEA. So if she's wrong on the BCEA, there is no self-standing Section 23 claim. And then the next section is Section 2195. And here, my understanding is that there is a self-standing claim to a gratuity based directly on Section 2195. But it is an utterly hopeless argument because the text of Section 2195 does not entitle the public protector to anything. Section 2195 says national legislation must establish frameworks for determining the salaries, allowances, and benefits of judges, the public protector, the auditor general, members of the commission provided for in the Constitution, including the broadcasting authority. So in its tenor and in its intention, that legislation is to impose a duty on Parliament not to determine the salaries, but to establish a framework for the determination of the salaries. So the Constitution itself does not determine anything. And it's irrelevant, therefore, to talk about salaries, allowances, and benefits. And even if, theoretically, one were to say that a gratuity is a benefit, its source cannot be Section 2195, because that section does not confer any exigible entitlements. It's simply to set out a framework. So there is nothing there. But in addition to that, it's plain that a gratuity stands apart. A gratuity stands apart. It may be provided for by the employer in its rules, in a contract. It may even be provided for by the state in a statute. But absent those rules, there is no common law right to a gratuity. So therefore, on Section 219, subsection 5, in its text there is no entitlement, and even if it fell under the category of benefits, it is irrelevant because it has not been conferred upon the public protector by any empowering instrument. What is then left of the case? On the declarator, there is nothing left. The first letter that came from the public protector on the 6th of December 2023 confined itself to the conditions of service. We have shown that the conditions of service give no rights. The pleadings then included a plethora of other entitlements from the Constitution to statutes. We've shown that under the BCEA there is no such right. Under the Constitution, there is no such right. Under the provisions of the Public Protector Act, which is Section 2, there is again no such right. Your Lordship can have regard here to item 20/2054. And all this thing says is the public protector shall be entitled to such salary, allowances, and benefits as determined by the President from time to time by notice in the Gazette after taking into consideration the recommendations of the Independent Commission and approved by...
Why shouldn't the court construe benefit to include gratuity?
Yes, I'm making two arguments on that. The first argument is that even if your lordship took the view that a benefit may include a gratuity, you still need to determine whether it has in fact included a gratuity or not. Because it's an entitlement based on something. It cannot be an entitlement based on a supposition. So you have to say, under this particular rule, there is a right to a gratuity, and here is the rule. And here, the only domestic rule we know of are the conditions of service. So that's argument number one. So even if one accepted the argument that sometimes a benefit would include a gratuity, it is an argument that goes nowhere. I know it was pursued with a lot of fervor yesterday, but it goes nowhere. Because it still takes us back to where we started. What is the rule that entitles the public protector to a gratuity as a species of a benefit? And there's only one rule, it's the conditions of service. But we also say that in general, and this is in labor law, in general, under section, in labor law now, under section 32 and 35 of the BCA, when one is defining a remuneration, which sometimes includes allowances and benefits, they are payments made in exchange of the services rendered. So for instance, a bonus, it may be that it's exceptional service, or for that matter, a benefit, it may be that it's medical aid or a car allowance. But they all constitute a package of remuneration that is due and payable to an employer. But when it comes to a gratuity, as the term implies, unless it's embodied in an instrument, it has no self-standing obligation that it imposes on the employer to pay it. And in fact, Your Lordship, I'm glad you've asked that question because it reminded me of something I missed when I was dealing with this. Because if you look at the actual instrument we were dealing with, which is 1839, that's the one I looked at, it has all sorts of other benefits. It has an entertainment allowance, which is not conditional upon anything, upon vacation of office or anything. It's payable. It has a medical scheme, again, that is payable, not conditional on anything. It has a motor vehicle scheme, again, that is payable. A settlement allowance, that is payable. The two categories, and then it has a transport and subsistence allowance that sometimes is payable, but under 8.11, there is a distinction drawn between vacation of office, removal from office, and then death. But when it comes to a gratuity, it's not made automatic, not made automatically payable. Its condition is vacation of office. So these conditions of service are a very useful illustration of the distinctions that are embodied in law between your baseline salary, allowances, and which are all here, and they are called allowances, and a medical scheme, which we know is a benefit, a motor vehicle scheme, which we know is a benefit, settlement allowance, different, subsistence allowance. But a gratuity is not even classified as a benefit, not even classified as an allowance, but is a standalone category. So I was thanking Your Lordship for raising that question because I noted that I had omitted to say that even textually under the instrument, a gratuity is set out as a standalone category, not as an allowance, not as a benefit, and not as baseline salary, but as a separate category, which is compatible, entirely compatible with South African legal system, that unless it's in an instrument, you can't just say, I'm coming to court, I want my gratuity. So to answer then Your Lordship's question, we say that when you read Section 2, salary allowances and benefits. Firstly, on its own text, it does not include gratuity. And secondly, in relation to the instrument that domesticates it, the gratuity is a standalone with its own conditions. And a gratuity for removal of office for misconduct and incompetence is expressly excluded. We would submit intentionally and for good reasons. So here, my Lord, we are not attempting to ask the Lordship to make any moral judgment at all. Simply an analysis of the instruments and to see whether in those instruments the right can be located. So this is then the fourth of these instruments, which is the Public Protector Act, and particularly under Section 2. So, which then, again, we ask the question rhetorically, what is left of this case? What then remains on the declarator is, well, there is some sort of unconstitutional conduct which is ill-defined. Because if you look at the framing of the declarator, it's a declaration that the conduct, that the conduct of the first or second respondents in refusing to pay the applicant the gratuity is unconstitutional. But there is no right that is relied upon in the Constitution that entitles the public protector to the payment of a gratuity, against which a refusal may be measured to test its constitutional validity. There are many rights cited in the applicant's founding affidavit. None of them deal with the subject we have today. So you cannot therefore have a generalized claim to unconstitutional conduct. It has to be a specific, the right must be pleaded and it must be proved. And that is why, therefore, we cannot even debate the issue of just an equitable remedy, because we can't get past Section 172(1)(a), which is there is nothing to be declared to be unconstitutional or invalid, because no case has been proved. So if you then dismiss the case of the declarator on the analysis that I have advanced to your Lordship.
Before you, still on this aspect in relation to the category that you have put up as unconstitutional conduct. Yesterday, when Mr. Mpofu was addressing the court inquired as to what conduct was being referenced, and the court was told the following as the conduct. And there were 5 aspects were mentioned to the court. The first one was that the applicant was impeached in September 2023. Second aspect was that she is due a remuneration within 7 days after she left office. Third one was that she demanded payment of remuneration through gratuity. Fourth aspect was that the first and second respondents replied that they had no powers and asked Parliament for guidance. And the fifth aspect was that she later received a letter conveying to her that she would not be paid a gratuity. I understood her case insofar as what constitutes unconstitutional conduct to be embodied in those 5 aspects. At least that's how the case was presented yesterday.
Yes. All right. Thank you, my lord. If we look at the pleaded case in the notice of motion, the conduct that is impugned there, it says declaring the conduct of the first and or second respondent in refusing to pay the applicant the gratuity is unconstitutional and invalid. So that's the conduct. It's the letter of the 12th of February 2024. And that is when the public protector said, you have not shown any legal instrument to entitle you to payment. So that's the case that they are asking for in the notice of motion.
So that will be the 5th aspect.
That would be
the 5
indeed,
points that I mentioned.
The fifth point, yes. So there is nothing about impeachment, although there is something about the BCEA in item 5. But we've addressed the BCEA. There's no point in repeating that. But there's also nothing about seeking a advice from Parliament or an opinion from Parliament. And there's nothing about lacking power or of any sort. So 3 of these items that were listed yesterday are just not in the notice of motion. In fact, as I understand, it was my learned friend who said that the impeachment is going on in a different, the challenge to the impeachment is going on in a different forum. So insofar as the generalized claim of unconstitutional conduct, it ultimately still reduces to the central point, which is, has she shown that she's entitled to the payment of the gratuity under the conditions of service? And if the answer to that is no, there can be no resort to an unspecified, generalized, unconstitutional conduct. So that then takes me, my lord, to the review, which is at item 6 of the notice of motion. It does require a bit of explication because of the confusing approach that was taken yesterday. There are 2 reviews that are available in our law. If one subsumes the common law under legality review. But this is not a review under the common law, it's a review under PAJA. And the second is the legality review. It's called here illegality in clause 6 of the notice of motion. So we have to do a proper analysis of the PAJA ground because the gateway to review is PAJA, the review of an administrative act. But the gateway to PAJA itself is the definition of administrative action. No 2 ways about it. So, which means that an applicant for review under section 6 and 8 of PAJA needs to prove that the decision meets the definitional elements of administrative action. I heard that my learned friend saying yesterday, we didn't object that the decision does not amount to an administrative act, but we did object. And then we said in the alternative, we will answer on the assumption that she can show that it is an administrative act and look at the grounds for review. But we objected that the non-payment, we said, is not an administrative act as defined in PAJA, and she had not proved that it was an administrative act. Now, this distinction is not a distinction we take because
it is nice to take. It is a distinction of immense importance. The first reason is what was articulated yesterday by Your Lordship, emanating from the Sequela judgment, that in law, PAJA cannot be invoked unless the decision in issue is an administrative decision. But the discipline of going through the 7 factors that are listed in the Minister of Defense versus Mutau, not the current Mutau, versus Mutau, is a gateway towards the substance of the decision. Why do I say this? In PAJA, in the definition of an administrative action, let's probably go through that definition, because I want to illustrate 3 elements of PAJA. 20. So it is apparently at 2040. 2040. 2040. Yes, it is here. So PAJA is at 2041 actually. So the first is, and this is the distinction that is drawn by PAJA. It says it means any decision taken or any failure to take a decision by an organ of state when exercising a power in terms of the Constitution or a provincial constitution, or Roman II, exercising a public power or performing a public function in terms of any legislation. So if the claim that is made by an applicant is that they are challenging a decision by an organ of state, it can only be an administrative act if it is an exercise of power under the Constitution or a provincial constitution, or an exercise of public power or the performance of a public function in terms of any legislation. Those words are crucial. So if under the Constitution, it doesn't have to be public power, it just needs to be power. But under the legislation, it needs to be a public power under the legislation or a public function under the legislation. That is when you want to challenge the decision of an organ of state, which means you have to choose whether the complaint is, I am challenging a decision of an of an organ of state. Because the next question is, which power was being exercised under the Constitution, and which public power or performance of public function was being exercised under any legislation. But if you are challenging the decision of a natural or juristic person, you don't have to show that it was under a constitution or under legislation, because that is regulated by B. You only have to show that it is an exercise of a public power or the performance of a public function in terms of an empowering provision, which is a different word to legislation or constitution. So an organ of state is challengeable only where they act under the Constitution or legislation. But a natural or juristic person are challengeable where they act under an empowering provision, which need not be the Constitution or legislation. Now, Your Lordship asked a pertinent question yesterday on the PAJA debate. Is the public protector complaining of a decision by an organ of state? My learned friend considered it was a decision by an organ of state, and he in fact said, we have considered that we are an organ of state. That is true. We've said that the decision was taken by the Office of the Public Protector. But then that is not enough, because if it is an organ of state, you are in category 1, which is in terms of what clause of the Constitution and in terms of what legislation is the applicant coming to court saying the decision was taken under. Now, that exercise we did at the beginning is now very helpful to actually look at the case as it started. So we look at what she said, the request to us. The request is at item 26, page 833. She said in paragraph 2.2, that's the former public protector, as you are aware, in terms of our client's conditions of service, and in particular clause 3 thereof, our client is entitled to payment of a gratuity. The final response made it clear that in terms of the conditions of service, which is at item 26, page 844, in terms of the conditions of service, she is not entitled because she was removed under section 194 of the Constitution by a resolution of the National Assembly, which was confirmed by the President. And then in paragraph 2.3, it made it clear, apart from the conditions of service, there is no other authority that our client is aware of, including the Constitution, as well as the Public Protector Act, which permits our client to consider paying your client a gratuity under circumstances where an incumbent is removed from office. So it's actually the opposite. They said, we cannot act under the Constitution. We cannot act under legislation. We can only act under the conditions of service. And under the conditions of service, a person who has been removed from office for misconduct and incapacity under section 194 is not entitled to the payment. So, Your Lordship will recall that I characterized the conditions of service as having no constitutional force, having no statutory force, only having contractual force. That then means, under the definition of an administrative act, there is no constitutional provision applicable, and there is no legislation applicable. And it fails at the first hurdle in satisfying the definition of an administrative action. And one cannot go to B either, because B says it must be a natural or juristic person, and then it says other than an organ of state. So there's an express exclusion of an organ of state. So this decision, as we know, was taken by the Office of the Public Protector, which might include all of the officials, including the Public Protector herself. But she was acting qua organ of state. So the first element in the definition is simply not satisfied at all, because the opposite happened here. The decision was taken under an instrument that has only contractual force. But in any event, this is an issue that should have been pleaded and proved in the founding affidavit, but it was not. It was not pleaded or proved in the founding affidavit. This is why we ended up with this oddity yesterday, when Your Lordship is asking about PAJA, and then there is a generalized reference to the pleadings, but no specific identification of the paragraphs that say this is where the elements in PAJA definition are met. And then there was a protest that said, if every time we come to court we must satisfy the 7 elements, where would we be? But the reason you have to satisfy the 7 elements is because if you cannot satisfy them, then PAJA is inapplicable, it's not available to you. And therefore, you are non-suited because you couldn't establish a cause of action. That is how the legal system works. You can't just say, I want to come to court and therefore I will say anything in the founding affidavit. And then we have shown Your Lordship the first problem with the failure to apply the discipline of going through the eye of the needle, which is in PAJA. Then the second problem with it is under, it follows under B, which is the decision itself must adversely affect the rights of any person, and it must have a direct external legal effect. So let's forget about rights for a moment, and let's look at the element of direct external legal effect. We know in Zaba, which is a judgment we have referred to, it's an employment case, and it was a dispute about promotion. A policeman came along and said, I've been denied a promotion, and this is administrative action. And the court said, the impact of the decision that was taken by the police is limited to you as a counterparty to the employment agreement. It is not an impact to the wider public. And PAJA is available in decisions that impact a wider public. So for instance, a tender is open to everyone. In fact, in paragraph 61, thank you, Zaba is at item 20 to 2296. And the relevant paragraphs are 64 and 65. And in paragraph 64, the last line says, well, the second last says, Section 33 does not regulate, as Section 33 of the Constitution, the relationship between the state as employer and its workers. But then this is the crucial part. When a grievance is raised by an employee relating to the conduct of the state as employer, and it has few or no direct implications or consequences for other citizens, it does not constitute administrative action. And then that is explained in paragraph 64, that the purpose behind PAJA is to regulate a specific category of decisions that have implications for the citizenry broadly. It is not to regulate a bilateral relationship, because the state acts in different statuses, different capacities. But PAJA is not intended to regulate the relationship between a bilateral relationship where one individual is affected. And the employment cases illustrate the point perfectly. And this is why they said, therefore, the decision does not constitute administrative action because it does not have direct external legal effect. It's a problem that Mr. Zaba has. This is the case here. It's a problem that Advocate Mkhwebane has. It's not the problem of everyone else. So that also still does not meet the definitional requirements, which is why it had to be pleaded and proved. And then there's a further problem, which is it must adversely affect the rights. Now, again, we need to analyze what are the rights that are affected, because the empowering instrument does not confer a right. This is not a case where a person is in receipt of a disability grant and there is a suspicion that it was fraudulently given and the state wants to take it away because they are in receipt of it and therefore they are entitled to receive it the following month. The state says it was fraudulently given and then the state wants to take it. There you can see a case where there is an adverse effect on pre-existing rights. But the problem here is that there are no pre-existing rights. And so this is now the fourth definitional element of PAJA that they are unable to satisfy. Because you look in the, you were told, well, look everywhere in the founding affidavit, you'll find portions of it. Never directed to the specific paragraphs. The problem is they don't actually satisfy the elements that are in PAJA. So, based on those four very clear mandatory requirements for the definition of an administrative action, they don't meet them, and therefore they cannot plead or rely on PAJA. But if they were able to rely on PAJA, why do they need PAJA? They need PAJA because they want to contend that Section 3, subsection 1, was not complied with, which is administrative action which materially and adversely affects the rights or legitimate expectations by any person must be procedurally fair. There are obviously two problems with their reliance on this as well. The fact is, it's not every administrative decision that entitles a person to procedural fairness. It is only that administrative action that affects rights and legitimate expectations. Now, yesterday we had very little about legitimate expectations because there is one line in the founding affidavit that says legitimately expected, and it's not expanded whatsoever. But the case ultimately evolves on the rights that they say are enforceable. So, absent the rights, no issue of procedural fairness arises. So we come back to, can we establish a right? But even if on the theoretical assumption there is a right that has been established, the problem is, what is the ground for saying there is no procedural fairness? Because what has happened here, my Lord, is actually straightforward. You know, there is a request made on the 6th of December 2023. There is a request made, and the request contains the legal justification for it. It contains everything, because it says our client vacated the office. So they already tell the public protector that the basis for the payment is vacation of office. And they also say 1 month before the expiry of the term. And then they say the conditions of service entitle you to pay my client in those circumstances. Even yesterday, those are the only facts that Mr. Mpofu argued were necessary to establish an entitlement to payment. So the request is made, I've vacated, the conditions of service say you must pay me where I've vacated. And then there is a response that says it's common cause that you were removed under Section 194 of the Constitution, and in those circumstances you have not vacated office, and therefore you will not receive the payment. Now, it is impossible to square that up with any procedurally unfair decision. It's just impossible. Which is why we've argued in our papers that because the decision substantially complied with PAJA, because a request was made, it contained all the information that was needed, a response was given. Of course, it was investigated first because they first went to Parliament, but that was all an internal investigation. But insofar as the applicant was concerned, she made a request, it contained everything that was needed, then she received a response. So that substantially complies with procedural fairness.
You will recall the exchange between the court and Mr. Mpofu on this aspect. I inquired from Mr. Mpofu as to whether, insofar as the applicant contends for procedural regularity, whether in the context of an absence of a hearing, whether that hearing had to take any particular form.
Yes, and sorry, my Lord.
Firstly, whether the hearing had to take any particular form, and related to that, whether it is the applicant who, because she's the one who says she did not have a hearing, whether it is required of her in law to indicate to the court what the form and content of that hearing might be.
Yes.
And Mr. Mpofu's submission was that it is not required of the applicant to have done that.
Yes, well, we do not accept that, because Section 3, subsection 2, A says a fair administrative procedure depends on the circumstance of each case. So the circumstances of each case, of this particular case, is that she has made a request. It contains all of the information to justify the request, and it contains the facts, because the fact is vacation, but it also contains the legal basis, which is clause 3 of the conditions of service. And then she gets a response that says your application there is no basis for us to give you the payment. So in the context of this case, that is sufficient. But if she says it's not sufficient, that's the point we make at paragraph 59 of the heads of argument. We say, in any event, the applicant does not point to any specific procedure which she says should have been followed in terms of the conditions of service or the Public Protector Act, bearing in mind that the procedure followed substantially complied with the requirements for procedural fairness under PAJA. The applicant was required to point to a different procedure which should have been followed in relation to a right that is legally sustainable and enforceable. She has not done so. So what she has done is to make a nebulous and a generic argument about procedural fairness, which ignores the fact of what happened here. And yesterday, what we then hear is it was because it was punitive. That's the adverse effect. But there is no punishment in saying to a person, the clause you have cited does not entitle you to a payment, and that is the position we've taken. There's no punishment there at all. She is not Robert Sobukwe, though it was argued yesterday that she was singled out like Robert Sobukwe. So we argue then on procedural fairness that the procedure followed substantially complied with what would have been required under 3, particularly because a fair procedure depends on the circumstances of each case. And if she didn't like this, she at least had a duty to say there is a different procedure in the conditions of service, or there's a different procedure in the Public Protector Act, and therefore I don't want to rely on PAJA. I have my own procedure, but we are ultimately on PAJA, and this procedure was compliant. So then we say, well, PAJA doesn't apply, but Section 3, subsection 1, read with Section 3, subsection 2, were complied with, and there can be no complaint about, no valid complaint at least about a hearing. Then I need to just address briefly I'll address the grounds of review, because it was said yesterday that it is immaterial whether the grounds are sourced in legality or in PAJA, the grounds are the grounds. But we must first address legality, because my learned friend supposes that by changing the label, you can escape the consequences of PAJA. But that is not the case. Even if you called this a legality review, the judgment of Rhino, I want to find that judgment, my lord. We've cited it in the so it's 201198.
Mr. Nkwetobi, in the citation of cases, that's in case line 20, and then the cases are numbered 1 up until the last one. It would be easier if you could just say to the court what the number
which
is.
item?
Yeah.
Oh, it's item 38, my lord.
38.
Yes.
Thank you.
So the case itself is at case lines 20/1198.
Yes, I'm there.
Thank you, my lord. And that is a legality review, and I would like to draw your lordship's attention to paragraph, okay, it starts at 30, 31, but really paragraph 32 that really summarizes the issue, which is, in order to be entitled to launch a legality challenge, you must show an adverse effect on rights. So you can't launch a legality challenge in the abstract. It must be grounded on an adverse effect on rights. And if there is no adverse effect on rights, the legality challenge is not available. And that is what Judge Plaskett was saying. In that case, it was in the context of a premature challenge. But the principle that he makes is of general application, because he says the situation is clear. Normandy's rights have not been adversely affected by the process so far, and it can point to no prejudice on its part at this stage. So you've got to show rights, you've got to show an adverse impact on those rights. So what are the rights that are, I will ignore Mr. Mbofu's constant chatting away. What are the rights that are at issue here?
not concerned that we have tolerated this 9 months for too long, the moment that the court was intervening. I'm not up to it, and I will not tolerate it when it's uncalled for. Especially I'll deal with it and imply all the misrepresentations. That's a different matter, but it's 9 months. No place here.
Yes, gentlemen, just reminding yourselves and everyone else that these are court proceedings.
No, it is the case, my lord. So when someone is always commenting and speaking loud, and then when they are called out on it, they protest. So what are the rights at issue here? There are no rights at issue because none have been established by reference to the conditions of service. And so it does not help to say, I don't have a PAJA claim, but I have a legality claim, because that just changes the label. But it does not excuse you from establishing the requirement to show that rights are impacted. So whether, therefore, they go under PAJA or they go under legality, the fact is they must still establish rights. And absent those rights, the claim cannot proceed. Then, if PAJA or legality are not available, and perhaps I may be wrong on that, what do I say then about the grounds of review? I've addressed the audi alteram partem rule. It was relabeled yesterday as procedural unfairness once it became a problem to go through the PAJA requirements. Relabeled as procedural irrationality. Yes, not unfairness. As procedural irrationality. But your Lordship remembers the judgment in Law Society versus the President, which made this point very clear that when it comes to procedural irrationality, that has nothing to do with whether or not an affected party was given audi before the decision was taken, because that is procedural fairness. When it comes to procedural irrationality, the question is whether or not the decision maker took into account all of the relevant factors in order to rationally arrive at a decision. So it is an inquiry into rationality. Sometimes, as it happened in the case of Scalabrini versus Minister of Home Affairs, sometimes the taking into account of relevant circumstances would impose a duty to hear a party likely to be affected by the decision. In Scalabrini, it was whether or not the government could close a refugee center without hearing the NGOs that made use of the refugee center. In Albert, the case was whether or not the government could introduce a scheme of amnesty without hearing from the victims. But the ultimate point is whether at the time you took the decision, you took into account all of the relevant circumstances and factors in order to arrive at a decision rationally. We then come back to domesticate the problem. In this case, they told us themselves on the 6th of December 2023, they told us themselves that they want to be paid because they have vacated office, and they want to be paid because they're entitled to the payment by virtue of the conditions of service, particularly clause 3. And when the decision is arrived at, which says that there is no cognizable claim under clause 3. That is having regard to the representations that have been made by the affected person who is interested in the outcome. It's not ignoring them. It's taking them into account because they wrote the letter. And so it was before the public protector. So there can be no complaint, at least no valid complaint. I know there was a lot of complaints yesterday, but there can be no legally valid complaint that this was on a procedural irrationality basis. This was a decision arrived at without taking into account the views of the person that would have been affected by the outcome because they triggered the process themselves. So that takes care of both Audi and the so-called procedural irrationality. There's just no case there whatsoever. And then we have the complaint of bias. Probably the best is simply to direct your lordship to the pleadings, particularly in the answering affidavit. So your lordship will find this we have dealt with it at page 29/21 of the answering affidavit. The answering affidavit itself starts at 29:2. And the answers are at 29:21. So in paragraph 19, it's the point I've already made. The decision not to pay the applicant a gratuity was both procedural and substantively correct since it did not involve a right that is legally sustainable and enforceable. And then in paragraph 19.2, that is a discrimination point. As I understood the argument, it was bias, stroke discrimination, stroke ulterior motive, stroke malice. But here's the answer at 19.2. The decision is not discriminatory. She's not being singled out. No grounds for discrimination or unfairness have been specified or established by the applicant. As I will explain below, the previous public protectors received the gratuity payout because they vacated the office after serving for the full 7-year term. The applicant, on the other hand, was removed from office as a result of a misconduct and incompetence. This differentiation is fair and rational. Then, if you turn over the page, 19.4, again, as I will demonstrate below, the applicant's allegations of bias, malice, and ulterior motives are completely unfounded and ought to be rejected. Now, you will obviously see the full explanation at paragraph 63.4. That you will see at page 29/33. I reiterate that the decision was not taken as a punishment or sanction, as illustrated by the process undertaken. Once it became clear that there was no authority on the basis on which a gratuity could be paid to a public protector who has been removed from office, I was not empowered to make such a payment. There is thus no basis to refer to representations on mitigation or reasons to avoid a sanction. And then paragraph 65 and 66. So The substance of it is actually straightforward. What they told her on the 12th of February were three things. One, you have been removed from office as a consequence of Section 194. Number two, the National Assembly has passed a resolution for your removal. Number three, the President has sanctioned your removal for misconduct and incompetence. We know those two documents. And then they say, but we compare your situation, even if you compare your situation to the previous public protectors, none of them were removed from office to start with, let alone being removed on grounds of misconduct and incapacity. I mean, misconduct and incompetence. Now, this is why it was interesting to hear yesterday that there was somehow a suggestion that that these grounds were not in the letter. Your Lordship's immediate retort was that, but the letter does contain the grounds. Then the argument went on, because they are encapsulated expressly. It's one thing to say it's implied. They're expressly encapsulated in the letter of the 12th of February. And this is what explains then why, when you look at our heads of argument, and again we have to address this because of the accusations of bias, accusations of unfair treatment, accusation of ulterior motive, accusations of malice. This is why then when you look at our heads of argument from paragraph 36, we have to spell out what that Section 194 committee, which is referenced in the letter to the Public Protector, found. For instance, to incompetence, it said, in relation to the charge of incompetence, as assessment of the evidence must reflect a demonstrated and sustained lack of knowledge to carry out and ability or skill to perform the duties of the public protector effectively and efficiently. At 36.12, the report finds that the applicant litigated recklessly and committed misconduct in utilizing the public protector resources to obtain legal advice and commencing litigation for personal gain. The report found that the applicant spent over 50 million rands on legal costs for litigation relating to 6 matters. The report noted at paragraph 244 that these costs are exacerbated where there are obviously no prospects of success and perpetual applications for leave to appeal. It continued that, save for one matter, Advocate Mkhwebane instructed that litigation on these matters ensue with several appeals and failed on the merits in all of them. And we look at the summary we gave at clause 36.2. The evidence shows lack of impartiality, particularly in relation to the SARS rogue unit report. And that undermined her credibility and integrity. Number 2, she was found to be in unlawful possession and utilization of classified information because she was in possession of a classified report by the Inspector General of Intelligence. She unlawfully received it, she perused it, and that constituted misconduct. And then she was in gross overreach of her powers. The evidence demonstrated that the applicant grossly overreached and exceeded her constitutional bounds. In this regard, her directive to Parliament to initiate a process to amend the Constitution represented a flagrant violation of Parliament's exclusive authority, showcasing her incompetence and disregard of legal boundaries. And the last one, alteration of reports and mismanagement of resources. The committee found that the applicant's alteration of the final report of the Freddie Dairy matter, giving implicated parties discretion to determine wrongdoers, removing referrals to investigative bodies, and producing untruthful explanations to the court, constituted serious misconduct. Additionally, her mismanagement of resources, leading to astronomical legal bills and expenditures, further demonstrated incompetence and negligence in her duties. So we can ask the question then, which other public protector in the history of the Office of the Public Protector has ever had these findings made against them? The answer is that it is Advocate Mkhwebane. And so when the Office of the Public Protector says to her, in these circumstances, we are unable to locate a statutory authority to pay you a gratuity, they are not being biased against her. They are not being malicious against her. They are not being unfairly discriminatory against her. They are telling the truth. Any other finding is just a distortion of the truth. They are telling the truth. So your Lordship can then, on bias, unfair discrimination, malice, yes, my junior, so let me just complete the sentence. On bias, unfair discrimination, malice, those ultimately revolve around a single fact, that everyone else was paid and I was not paid. Then we deal with the matter, in any event, of the other public protectors, the comparator, at page 29/10, where in paragraph 14.5 we say the three people, what she says, the three people appointed to the position of public protector prior to the applicant had held the office until the expiry of their 7-year term. Advocate Selby Bako was appointed on the inception of the office in 1995 and remained in the position until 2002. He was succeeded in 2002 by Advocate Lawrence Mushwana, who served as the public protector for the 7-year term until 2009. In 2009, Advocate Thuli Madonsela was appointed as the public protector. She too served in the position for the full 7-year period. Oh yes, apparently what I should have read is 14.4, which is, this was the first time that the National Assembly had invoked the procedures prescribed in section 194(1) of the Constitution for the removal of a public protector, and the first time that the President had removed an individual from the office of the public protector in terms of section 194, subsection 3, subsection B. So again, Advocate Mkhwebane is not Robert Sobukwe. She is not getting the gratuity because the instrument does not permit the payment of a gratuity to a person removed from office for misconduct and incompetence. Then the next ground of review is the taking into account of irrelevant considerations. But when you ask yourself, well, what are the irrelevant considerations? And the reason why, again, one needs to drill down to the evidence is because the considerations that the public protector advanced should be taken into account are at page 18/82. Those are the considerations she claimed should be taken into account. She said, our client vacated the office on or about 12 September 2023, 1 month before the expiry of a term of office. Now we know the sequence here. 11th of September, the Parliament passes, the National Assembly is passed. 12th of September, the President issues a letter removing her from office. Paragraph 2.2, as you are aware, and in terms of our client's conditions of service, and in particular clause 3 thereof, our client is entitled to payment of a gratuity. Those are precisely the considerations they took into account when you have regard to page 18.87. They said you've been removed as a result of a resolution of the National Assembly, which the President acted under in terms of section 194. And then they said, we've also looked at these conditions of service, and we have established that under the conditions of service, vacation is not removal, and therefore you are not entitled to payment. So there are no irrelevant considerations that were taken into account. In fact, the considerations that were taken into account were foreshadowed by the Public Protector in her correspondence and then responded to by the previous Public Protector and then responded by the Public Protector. They are highly relevant insofar as they inform the correct decision-making matrix. And then, my Lord, that takes care of the review. To sum it up, they have not shown that there is an administrative action that would trigger the application of PAJA. They have not shown that any rights that they have in law are adversely impacted, which would trigger the application of the legality principle. They are just wrong when they claim that there has been a change in the reasons. That's just wrong. It's not the case. Your Lordship just needs to look at the letter. What has happened, of course, is that an answering affidavit fleshes out the reasons, but it's the same reasons. And then they cannot show that there is any irrational discrimination. And the fact that a public protector who has been found guilty of misconduct and incompetence and removed from office as a result of that does not get a gratuity is completely compatible with the scheme of the Constitution. It's totally compatible. It is an objective fact, not targeting an individual, because anyone else who falls into that category will know from now on that South African law says I have to respect my oath of office when I assume that position. If I act in violation thereof, I will not get my gratuity. End of the story. But it is also a factor that serves a legitimate constitutional purpose. It is an entirely legitimate constitutional purpose to say that as a matter of South African law, someone who has no respect for the oath of office should not get a gratuity. And that legitimate purpose, and Mr. Mutau has articulated this better than us in the heads of argument, is constitutional accountability. And hopefully he will expand on the concept. It's constitutional accountability. Because the values that are in Section 1, which include accountability, apply across. They apply even with stricter validity when it comes to a person whose primary job is to uphold the Constitution. And this is why in our heads of argument we've relied to the South African Reserve Bank case to say the holder of that office is the primary instrument through which South Africans expect the values of the Constitution would be lived. And when there is a negation and a disregard of the values of the Constitution by the holder of the office, that is meant to be a standard setter for all of us. It is a legitimate thing for the law to say, in those circumstances, there will be no gratuity. It is an entirely legitimate thing. Otherwise, what you have is a free-for-all. What you have is a reward for constitutional delinquency. And this, I'm afraid, my Lord, is the big elephant in the room. But this case, really what it is about, is asking the judge to be party to a reward of constitutional delinquency. So we say that the distinction, it's true that there is a distinction, but it is a rational distinction. It is also an objective distinction. It also serves a legitimate constitutional purpose. And that is why we submit, therefore, that your Lordship will not find that there are other reasons outside of the declarator, the review, and some other freestanding constitutional reasons. We then say to your Lordship that there is a costs issue that needs to be addressed. We have seen in the arguments made that there is a personal cost that is sought against Advocate Kholeka. But it has no basis in law and no basis in fact. We have addressed this at paragraph 69, 70, and 71. In fact, the correct approach, my Lord, which is from the judgment of Zuma versus Democratic Alliance and another, an SCA judgment, particularly at paragraphs 47 to 52. What you have here, you've got a part...
Paragraph what? 52?
Yeah, 47 to 52. It's a judgment by, I think it's Judge Ponan, if I'm not mistaken, but we've cited this at footnote 108 of our heads of argument.
Right.
The correct approach in cases like this, my Lord, is that if you have an applicant that comes to court with a slew of reckless accusations which cannot be established on fact, and insults, quite a lot of insults that cannot be established on fact, of malice, of bad faith, of vindictiveness, of bias, of not taking a decision that is genuine. And that tenor, which is a series of outlandish allegations, runs through the founding affidavit and the supplementary affidavit. I'm afraid also in the heads of argument. And yesterday, you would recall accusations of manufacturing the pleadings. Now, that runs through the entire founding affidavit. The Supreme Court of Appeal has said this must end. Now, unfortunately, there is a sense of helplessness among the judges about how exactly do they address this kind of litigation, where instead of setting out a case and a legal case for the basis of the case, what then happens is that the case is then expanded to cover extraneous matter, which is nothing but insult. Sense of helplessness among our judges about how to address this. At the very least, Judge Ponan said, one of the powers we have is costs. At least that is still within judicial control, is costs. And costs must also be awarded in a case where outlandish allegations, which have no bearing on the matter, are made to color the texture of the affidavit and to color the atmosphere of the hearing. And so that is why we ask that it's actually the opposite, is that in the light of the manner in which this case has been litigated, it is necessary, regrettably, to ask a Lordship to follow the line of Justice Ponan, which is, but this thing must end. At some point it must really come to an end. And that's why we ask that when you consider costs, you've got to consider a punitive cost against the applicant, which would be on an attorney and client scale. My recollection is that that was the cost order imposed by Judge Ponan as a mark of displeasure to this kind of litigation. Thank you, my Lord.
Thank you very much. Mr. Mutau?
My Lord, I wonder if Mr. Mutau doesn't want to come here.
Inspector, you do, my Lord. It would require that we reorganize. And I'm not sure, my Lord, it's 25 to 1. Thank you. Thank you.
Lord, could you just give us 2 minutes just to
Shuffle.
to move?
From the podium, not for reasons based on incompetence. And the other recognized categories in section 194, and specifically misconduct in this case. Your Lordship would know that one of the important considerations when in the sequence of betting, the heavy lifting has already been done. One does not reinvent the wheel.
Yes, I was about to implore you that to the extent that the case advanced by the Speaker coincides with that made by the Public Protector and her office, and where the argument is the same, that that perhaps you will not repeat that and deal with those aspects which the first and second respondents didn't address to the court.
Thank you, my Lord. We will follow that well-established discipline and practice. And my Lord, what we have done also for purposes of trying to save time, it is to prepare a presentation note. And the idea of the note is the following, my Lord. It dissects the pleadings by locating the case that is pleaded by the applicant, and it informs your Lordship where the Speaker's answer to those allegations is to be found, and very briefly what the Speaker's answer is, so that when your Lordship considers the matter and writes a judgment, your Lordship helpfully has a note that assists, hopefully for that purpose. But secondly, it will also avoid the need for His Lordship to make copious notes in the course of the address. So, my Lord, with your leave, I beg leave to hand up a copy of the Speaker's presentation note. And my Lord, before I deal with the note, and in particular the relevant aspects that we wish to emphasize, may I refer your Lordship to one of the old decisions that are known in respect of a mandamus. And it is not in our heads of argument, Lord. It's the well-known decision of Kaunda and others versus President of the Republic of South Africa and others. It's reported in 2005, Volume 4, SA 235. It's a decision of the Constitutional Court. And Lord, it simply articulates this well-known principle just to complete the one element that was not dealt with by my learned friend, Mr. Ngqobi. And it is the following, that your Lordship will recall that for purposes of the competence of the invocation, or the lawful or competent invocation of a mandamus, the public body that against which a mandamus is sought must be under a statutory obligation to perform the obligation under review. You would say, for example, if you're dealing with Home Affairs and you want to compel Home Affairs to issue a passport or a permit, the first question is you look to whether, as a matter of law, that organ against which a mandamus is sought to be enforced has that legal obligation or not. So, my Lord, I'm just simply illustrating that principle, but that debate has already taken place between our learned friend and Mr. Ngqobi. Then, my Lord, one other important principle to mention is flowing from your Lordship's question yesterday, when your Lordship asked our learned friend in relation to clause 8.11 of the service of the conditions of service, and your Lordship asked the question pointedly in the following terms. Your Lordship said, well, if the term removal is subsumed into vacation of office, then why does the instrument refer to that term in clause 8.11? And your Lordship will recall the response thereto was, well, it's tautology. Lord, simply to give your Lordship the authority of the Constitutional Court that deals with the subject, or in fact the principle that buttresses the submission by a learned friend on behalf of the first and second respondents. My Lord, it's the decision of Minister of Finance versus Afri-Business NPC, reported in 2022, Volume 4, SA 362. And in paragraph 109, in a judgment penned by His Lordship Justice Madlanga, the court says the following: in saying the only restriction placed on the minister's power to promulgate regulations is that the regulations should act in furtherance of the objects of the Procurement Act, the first judgment effectively strikes a line across the words necessary or expedient. It cannot do that. On first principles, our jurisprudence on interpretation requires that each word must, as far as possible, be given meaning. The first judgment does not suggest that no meaning can be given to these words. Rather, its approach appears to relegate them. Then there is a footnote, and it's footnote 91 to the judgment, where reference is made to a decision of Wellworths Bazaar Ltd versus Chandler Ltd and another, in which, my Lord, it is stated the appellate division, as it then was, held that a court should be slow to come to the conclusion that words in a statute are tautologous or superfluous. In similar vein, in a minority judgment in National Credit Regulator versus Opperman and others. It's a decision of the Constitutional Court. Cameron J. said in paragraph 99, a long-standing precept of interpretation is that every word must be given a meaning. Words in an enactment should not be treated as tautologous or superfluous. Although the majority and minority judgments differed on the meaning of the provisions at issue, there was no disagreement on this established principle. And my Lord, okay, sorry, I was struggling to follow what is happening. My Lord, the issue is the following, that the conditions of service make a conscious distinction between vacation of office and removal from office. And the argument as we understand it would be tantamount to asking your Lordship to strike a line in clause 8.11 by ignoring removal from office, and your Lordship to find that the word is tautologous and thus it is a vacation from office is synonymous with removal from office, my Lord. And we say with respect on first principles of interpretation as articulated by His Lordship Justice Madlanga, that would be incongruent with those principles. Then, my Lord, against those introductory remarks, if I can just ask your Lordship to then go to the note. One of the questions that your Lordship asked yesterday was, what is the nature of these conditions of service? And my Lord, the answer as we understood is one that was inconsistent with the applicant's pleaded case. And this is the reason why we thought to answer that question, we should attempt to reference the pleadings so that at least your Lordship will have a basis from which to move in understanding what the applicant's pleaded case is in relation to the instrument on which she places reliance. My Lord, in the introductory section, we deal with her appointment and the fact that her appointment was governed by conditions of service which embody the terms of her contract of employment. And the reference that this is what the applicant says. In other words, the conditions of service articulate her terms or the terms of her contract of employment. Your Lordship will find in the footnote, the second footnote, your Lordship will see that references the conditions of service, and in paragraph 5 of the note, Lord, we then reference paragraph 62 of her founding affidavit, where the applicant says the following. It says, in this section, we deal with the relief sought under prayer in respect of the merits against the background of the facts and legal provisions mentioned above. Then importantly, in spite of the detailed factual background, the number of legal provisions relied on, and the public importance of this matter, the legal issue which falls for adjudication is quite straightforward and is centered around the interpretation of the relevant clause of the service conditions with the purpose of either applying it in a constitutionally compliant manner or declaring it invalid, null, and void as the case may be. Now, my Lord, on her pleaded case, it's a contractual dispute. No more, no less. The issue that would follow is whether there is any controversy that arises from that interpretation of the contract, i.e., does the contract stipulate the circumstances under which a gratuity is payable? And do those circumstances encapsulate a situation where a public protector has been removed through a constitutionally sanctioned process that was pursued in terms of Section 194, i.e. for misconduct and incompetence? We submit that's a straightforward exercise of interpretation. We adopt the language used by the applicant, that it's quite a straightforward interpretation of that instrument. And my Lord, it is for that reason that in our heads of argument, Your Lordship saw that we deal with the fact that there is already an antecedent decision that has already been taken by Parliament in determining the conditions of service, inclusive of circumstances when a gratuity is payable. If I can just perhaps take Your Lordship there, or at least just give Your Lordship the reference. Your Lordship will find that topic in our heads of argument commencing at page 31-46. Paragraphs 124 and following, where we make the submission: in this instance, the framework of the salary and benefits of the public protector falls within the remit of the National Assembly and has already been determined thereby. So there's no issue, my Lord. And it is for that reason that the public protector, when faced with a request to pay a gratuity, she did no more than to convey a consequence that would follow by operation of law. What do we mean by that, Lord? If the conditions of service have already predetermined the issue in the terms as we've stipulated, there is no exercise of a discretion that is available to the public protector to determine whether to pay or not to pay. Put differently, there could be no exercise of a discretion by the public protector that could return a finding that in these circumstances, when a constitutionally prescribed sanction followed upon the findings that were made as an expression by the committee in respect of the conduct that it interrogated, Lord, it was not open for the public protector to arrive at a different conclusion, because one would have to say, well, if you look at clause 3.1, clause 3.2, and clause 8.11, which is where the cause of action is grounded, Lord, where is a recognized category that allows for payment of a gratuity in circumstances where a public protector has been removed and has not vacated in the circumstances as articulated by the instrument itself? And my Lord,
Mr. Mtho,
yes,
but it seems to me that there is coincidence between the speaker and the applicant that as to whether or not payment is due, one has to look to the conditions of service. So there's no dispute.
There's no issue there.
On that aspect. The issue is whether or not the conditions of service are applicable.
Well, not whether they are applicable.
Well, I put that in
Yes.
elegantly. Are applicable in the sense of whether, as
They
construed, rather that whether a construction of the conditions of service result in her being entitled to a gratuity.
Yes. In fact, yes, your Lordship is quite correct. But we say, even at the level of basic principles, on the construction of the relevant clauses of the instrument pursuant to which the right is sought to be predicated, my Lord, no controversy arises, because it's simply to look at the instrument and to apply it on its terms. And it is for that reason that we say, Lord, that is merely applying the consequences that would befall a public protector that has not vacated, i.e., has not satisfied the jurisdictional prerequisites that are outlined in the clause. So, in communicating that decision, the public protector did nothing more than to spell out the legal consequences that would follow.
On that view,
Yes.
It seems to follow that, as far as the Speaker is concerned, there was no decision by the Public Protector.
Yes. Yes, my Lord. That would. And if I might just ask your Lordship to turn to our heads of argument at P31-50, commencing at paragraph 139.
Right.
Lord, therein we make the submission that accordingly, the contention by the applicant that the public protector made a decision in relation to her claim for payment of a gratuity is factually and legally incorrect. We reference the Plovest Nest decision of the Supreme Court of Appeal, which laid down the principle that the mere communication of a decision does not constitute a decision which is subject to administrative law under PAJA. Lord, we also reference the Penity decision. Your Lordship would have seen that even in applying those principles, and in particular at paragraph 9, the highlighted portion thereof, if one applies what would follow as a consequence of law, well, there is no question of a review of an administrative decision. Indeed, the coming into operation of the deeming provision is not dependent upon any decision. The court held further that whereas in that case, and also the present matter, the employee is informed in a letter of discharge that she has been discharged in terms of section 72(1), in this case section 14(1)(a), it is not the consequence of a discretionary decision, but merely the notification of a result which occurred by operation of law. Now, my Lord, similarly, the Rhetorical decision expresses the similar principle, which we refer to in paragraph 142 of our heads, the Rhetorical decision of the Constitutional Court of Law. And my learned friend, Mr. Mkhwebane, spent quite some time in articulating the letter of the 12th of September. And in that letter, your Lordship heard, and in fact your Lordship would have seen, there is a constraint which is expressed by the public protector to say, I cannot find any lawful instrument which would authorize me to pay you a gratuity in circumstances of a removal in terms of Section 194 of the Constitution. Nothing more, nothing less. And, my Lord, on following those principles, which we submit, find application herein, Lord, there is no decision that's capable of review.
Right. Mr. Mdal, I'm going to suggest that having concluded this aspect, that the court will take its luncheon break.
Yes.
And I believe yesterday I did indicate that the court will sit at 2, so the court will sit at 2.
At 2 o'clock.
Yes.
Thank you, my Lord.
No excuses this time.
Thank you, my Lord.
Court will rise.
Even when I'm here.
I remember when you were there,
the fact that the primary job of the public protector is to uphold the Constitution and to ensure that the public administration also does so. And your Lordship will recall the submission that was made, that it is from the prism of these legislative instruments, or at least these constitutional instruments, that your Lordship will have to look in determining whether the public protector is an employee or not. We are not repeating that debate, but simply to provide additional constitutional constructs that locate the office of the public protector. Then we, in paragraph 10, refer to the notion of the two bases upon which the applicant was removed from office, and we ask the question, Lord, we say it is against the aforestated principles that this Honorable Court has to determine whether, having regard to the terms of conditions of service, the provisions of the Public Protector Act, the BCEA, and the Constitution, it is constitutionally sound to pay a token of appreciation in the form of a gratuity to a public protector who has been removed on account of misconduct and incompetence. And in the next paragraph, we refer your Lordship to the rules of the National Assembly in which these two concepts are defined. And these are the two concepts as referred to in section 194, 1A. Lord, 11.1, the rules define misconduct as the intentional or gross negligent failure to meet the standard of behavior or conduct expected of a holder of a public office. Then incompetence is defined as including demonstrated and sustained. It should be a sustained lack of knowledge to carry out an ability or skill to perform his or her duties effectively and efficiently. So the injunction, as we had mentioned earlier, is a constitutional standard against which a removal has to be tested, as set out in section 1941A. So when you invoke that statutory or rather constitutional provision, you are purely in the realm of a standard that the Constitution has prescribed. And it is against that standard that one has to test whether, in rewarding a public protector who has been found not, or who has been found wanting for purposes of failure to display these two constitutionally prescribed injunctions, ought to be granted a gratuity. Lord, in footnote 8, we reference the economic freedom fighters' decision, which we also deal with in paragraph 151 of our heads, but your Lordship does not need to go there because we give your Lordship the reference to say in our heads, that's where your Lordship will find it. And in paragraph 115 of that decision, the Constitutional Court articulates the principle that public office bearers ignore their constitutional obligations at their peril. And if I might just pause here, Lord, and refer to one of the issues that arose during His Lordship's engagement with our learned friend for the applicant. There was a misunderstanding with respect of what His Lordship had said, or the remark that His Lordship was making with reference to the fact that the public protector had been found guilty by the committee. Because your Lordship, as you know, for purposes of these proceedings, would only have to note the existence of those findings and the basis upon which those findings were arrived at His Lordship is not being called upon to make a determination whether those findings are correct or not. That's not what His Lordship is being asked to do. But as a matter of fact, they do exist. And for that purpose, it would be important for Your Lordship to note them, because Your Lordship is being asked by the applicant, and we've said there's no need to go outside the four corners of the contract of service. But in an attempt to buttress her case, what she's essentially saying is the payment or the refusal to pay a gratuity implicates some constitutionally unfair outcome in breach of the rights that are listed. And it is for that reason that in Your Lordship's analysis of the facts and in determining whether what His Lordship is being implored to arrive at by way of statutory interpretation can competently yield an outcome in circumstances where we say Section 194 imposes an injunction, there are those two terms that are defined, and that if you uphold a simple interpretational outcome of the conditions of service, the result, Lord, would be constitutionally compliant because it is grounded on Section 194. Whatever fight that there is out there that we are being told about, that there is a challenge to the findings of the committee, etc., that will be dealt with in that court. But with respect, the existence of these findings are important for Your Lordship's purposes, because it is a constitutional standard that Your Lordship is being implored to invoke, albeit incorrectly by way of pleading on the part of the applicant. Well, I'm being told it's footnote 6 or footnote 8. I'm told it's paragraph 115 of the heads. Sorry, but might I just check what the... Sorry, my Lord. 115 is the reference. I think the footnote is correct in the sense that 115 is the reference to the decision, the Economic Freedom Front decision. In other words, where Your Lordship finds the principle that public office bearers ignore their constitutional obligations at their peril. Then, my Lord, if I can then move, the next topic that we deal with in the note is an analysis of the applicant's cause of action and the relief that is being sought. And here, my Lord, the approach that we've adopted is the following. We identify where the applicant pleads a particular fact, and we identify where the speaker deals with it in her answer. And as I indicated for purposes of the introduction, I had indicated that the collation of the pleadings, both in terms of relevance and location, we do it purely, Lord, for purposes of assisting Your Lordship. Lord, if I can just, perhaps in dealing with what the applicant identifies under Section D1 of her founding affidavit as a claim that is premised in common law. Part of the topic that we deal with is an issue in the last bullet on page 5 of the note, where, Lord, we undertake a comparison in an attempt to indicate to Your Lordship that removal from office is distinct from vacation from office. Lord. And we make the point that the payment of a gratuity is a form or token of an acknowledgement or appreciation of a public protector's service above and beyond his or her salary and other allowances. And in particular, it serves to deter a person occupying the office of public protector from engaging in misconduct or acting in an incompetent manner. So there is an incentive and a deterrent that's being served by the gratuity. And for a full iteration thereof, Lord, in paragraph 14, we refer, Your Lordship, to paragraphs 96 and 98 of the Speaker's answering affidavit. And if I may, my Lord, just for purposes of making this point, ask Your Lordship to go there. It's at page 02-76. So 02-76. And my Lord, the Speaker makes the point, commencing in paragraph 96. She says, the distinct purpose of paragraph 3.1 of the service conditions also supports the conclusion that the payment of gratuity pursuant to the vacation of the office of the Public Protector excludes the removal of the Public Protector as envisaged in section or by section 194 of the Constitution. The purpose of providing a gratuity to the Public Protector is to serve as a form of token of conditional acknowledgement of appreciation for their service, above and beyond their salary and other allowances. This not only rewards a Public Protector who has vacated office voluntarily or through the natural expiry of the term of office, but also plays a crucial role in deterring persons who occupy the office of Public Protector from engaging in misconduct or acting in an incompetent manner. Then, the Lord, in paragraph 97, the Speaker tells Your Lordship, this purpose is not served by providing a gratuity to a person who has been removed from the office of the Public Protector on the grounds of misconduct or incompetence, and who does not voluntarily leave office or finish their term of office. When a Public Protector is removed from office based on their misconduct or incompetence, it amounts to a breach of the standard of conduct required from office. And we know this is a constitutionally set standard. Providing a gratuity in such circumstances would contradict the purpose of the gratuity, which is to honor the satisfactory discharge by a Public Protector of their grave responsibilities. It would also undermine the integrity and esteem of the office of the Public Protector and dilute the principle of accountability insofar as it would guarantee financial security / reward, notwithstanding incompetence or misconduct. It would therefore also erode public trust in these institutions, as gratuity is paid from the taxpayers' funds. So, Lord, it is in that context that one equates the payment of a gratuity in the context of the contractual provisions read with the Constitution for purposes of the Public Protector with a standard of constitutional accountability. Then, my Lord, we proceed in paragraph 15 by referencing what we deal with in our heads of argument as some of the findings of the Section 194 committee being the basis upon which the applicant was removed, and we allude to the fact that some of these include failing to observe the basic element of procedural fairness and transparency in acting far outside of her powers and in failing to observe scrupulous honesty in her submissions to the court, and thereby acting in a manner that would have destroyed a reasonable member of the public's confidence in her ability to discharge her duties and functions. In respect of the Friede investigation and report, she failed to protect the position of the interest of the beneficiaries and to hold implicated politicians to account and provide effective relief in respect of money that Estina had spent, and thereby breaching the constitutional imperative of accountability, making contradictory and implausible statements under oath, and failed to observe the standard of honesty and act in accordance with the heightened duty owed to the court, demonstrated incompetence in misinterpreting the law, handled a report of the Inspector General of Intelligence in a manner that was not only dishonest, but was also unlawful, and thereby misconducting herself in that regard, and grossly misconducted herself by making a scathing, unwarranted, and personal attack on the integrity of Justice Potterhill, who handed down a judgment concerning the applicant's conduct. And, my Lord, in paragraph 16, we ask your Lordship to have regard to and bear in mind what the Constitutional Court said in paragraph 155 of the Public Protector decision, being that the Public Protector is the Constitution's principal agent to respect the law, to fulfill procedural requirements, and to tread respectfully in dealing with these rights. So, my Lord, it's quite an important scheme when one locates these obligations within the normative values of the Constitution against which one would test the complaint that in implementing the terms or the conditions of service, Lord, in their plain terms as they appear, your Lordship would be doing an injustice to the applicant and all.
Mr. Mtalo, the case that the Speaker seems to be advancing is that, according to the Speaker,
Yes.
well, the Speaker takes a view that the applicant can't be entitled to a gratuity, not on the basis of the wording of the
Conditions of service.
clause 1, but on the basis of all those aspects that we have been advancing to the court. I mean, that seems to be the substance of, at least as I'm understanding your submission up to this point.
Lord,
So because those submissions are done on the face of it are not grounded on clause 3.1. They appear to be grounded on what conclusions one may draw given what the Speaker contends to be the nature of a gratuity and what the committee found following its inquiry. So then they seem to be quite distinct from, that is, on the Speaker's view, this court doesn't even have to consider the conditions of service. I mean, that's as I'm understanding your submission up to this point.
No, Lord. Your Lordship will recall when we started, I said I'm not going to repeat the grounds that have been covered by my learned friend on behalf of the first and second respondent.
Yes.
And in our heads, Lord, and also in the answering affidavit, the Speaker's primary case is that on the proper interpretation of the conditions of service, i.e. clause 3.1, 3.2, and 8.11 thereof, there is no entitlement to a gratuity. And I simply did not...
There is no entitlement, again, based on your submissions up to this point, there is no entitlement because of the findings by the committee.
No, my Lord. Let me go back. We start with the main argument, which we are not abandoning in our heads, and I was purely doing this for purposes of experience.
Yes.
The first point is we have engaged in the interpretational exercise, and perhaps just to locate it for your Lordship, this is in our heads of argument. If your Lordship has regard to the principles that we deal with, commencing from paragraph 12 of our heads, page 31-9. And if I can deal, my Lord, just for purposes of emphasis, with paragraph 15, where we make the point that the starting point is to have regard to the words that appear in the clause, to ensure that it remains tethered to its context and structure. So this is not a case, my Lord, that is purely supported on the submissions that I'm making now.
Yes, well, I understand that the Speaker stands by the submissions as drawn, and that the note is, as you indicated, to assist the court.
Yes, my Lord. And in particular, my Lord, perhaps if I can just allude to this principle that we deal with in the second sentence of paragraph 15, which is that in the event that the service conditions are open to multiple plausible interpretations, then the one that best promotes the spirit, purport, and objects of the Bill of Rights and conforms with the Constitution should be preferred. Lord, this does not mean we abandon, as it were, the principal submission which we deal with commencing from paragraph 22 of the heads, which is the correct approach to the interpretation of the service conditions. That's where your Lordship will find the topic. And your Lordship will see, commencing from paragraph 22, we engage with the enabling provision from which the entitlement to a gratuity is being sought. And that we deal with from paragraph 22 of the heads, Lord. Just above paragraph 26, we deal with the fact that vacation of office is distinct from removal from office. And in particular, we say the following in that regard. The phrases vacation of office and removal from office have different connotations and implications based on their standard usage and context. Vacation refers to the positive state of the office of the public protector being empty, rather than the action taken against the individual upholding the position.
Yes, right, yes.
And my Lord, we go on, we explain what removal is, and the engagement with the clause, with the provisions of the conditions of service. We start from paragraph 27 of the heads. I simply was avoiding, my Lord, to repeat the argument. Because
yes. No, I follow. It's just that the manner in which you were making the case. But I do understand and accept that the Speaker stands by her submissions.
Yes, my Lord. And the only point I'm dealing with, it is on the assumption that because Section 194 is located in the Constitution, and we know that there is an invocation by the applicant of various sections of the Constitution, we say, if your Lordship has regard to that argument, this is how one would look at it for purposes of ultimately determining whether that case can actually yield the kind of interpretation that the applicant is imploring your Lordship to arrive at. So, my Lord, we deal with the entirety of the clauses, in particular 3.1, read with Section 2.2 and 2.3 of the Public Protectors Act. And your Lordship will find that from paragraph 27 to paragraph 42.
Yes, no, I didn't mean to now have you address the court, because I've considered your written submissions.
Thanks, my Lord. So, it is for that reason, my Lord, when I started by saying, depending on where you are in the betting lineup, you look at the scoreboard and what the scoreboard reflects, and Lord, you deal with, I mean, that would inform your approach, whether you bet aggressively or you bet in terms of the medium approach, etc., etc. So, my Lord, it's purely from that I didn't start with that argument on the proper construction of 3.1, 3.2.
If no, I've considered them because they are in your written submission.
In our written, thanks, my Lord. Lord, in dealing with the next section, what we've done is the applicant has divided her founding affidavit into sections. Section D1, D2, D3, and we followed that format in the note, so that we say, like, for example, if your Lordship has regard to paragraph 17 of the note, that is where we give your Lordship the place where your Lordship will find where we engage with the interpretation of the clause. Then when we deal with the next topic, we say in D2, the applicant deals with illegality on the basis of legislation, and for this she relies on these provisions in the first bullet.
Forgive me, Mr. Mkhwebane, but I have considered the pleadings, and I've considered what the applicant says in her case and what the respondents say, and as it happens, I've made my own table of the pleadings, what is cited in the pleadings, and what each respondent says.
Thank you, my Lord. Thank you. Then, my Lord, in D3, section D3, which your Lordship will find on page 8 of the note, this is after the conclusion that there is no legislative basis when we deal with the two referenced statutes to pay a gratuity in circumstances similar to this case. Then in D3, we deal with the alleged constitutional breaches, and we list them in the manner that the applicant has. Lord, we think it's purely a typographical error that one of the rights that the applicant alleges to have been breached is section 172, because we don't make much of that. Then, my Lord, we make the submission on page 9 of the note, the first bullet, that captures the essence of the Speaker's answer to that constitutional claim. The conditions of service need to be interpreted in a manner that best promotes the spirit, purport, and object. This entails an appreciation that the powers to be exercised by a public protector come with the responsibilities, and a public office bearer who occupies such a position of high authority and who must be held accountable in exercising his or her powers. And the public protector is required to exhibit highest tenets of integrity, professionalism, transparency, and accountability. And, Lord, I've dealt with paragraph 15, or rather the point that we make in footnote 15 and footnote 14. I dealt with that earlier. If I can then, Lord, deal with the part about the applicant's invitation that the court should invoke the values of fairness, reasonableness, justice, and ubuntu. We deal with that in paragraph 18, and we make the following observation, Lord. In her founding affidavit, the applicant says, in addition to the above, she will invite the court to invoke values such as fairness, reasonableness, justice, and ubuntu, the details of which, I'm advised, will be further discussed during legal argument. And, Lord, you will see when you go to that paragraph which we've referenced in footnote 15, in which we make the point that notably no facts supporting the invocation of these values have been pleaded, but rather the applicant says she was advised that these values will further be discussed during legal argument. So your Lordship will look in vain in the founding affidavit to see how is Ubuntu pleaded and how is its breach invoked together with those concepts that we set out there, Lord. But in particular,
will the court have to, can the court have regard to Ubuntu, however it's defined in interpreting the clause 3.1?
My Lord, may I ask your Lordship perhaps just to immediately jump from the note, from paragraph 18, which is where we are, to go to paragraph 23.6.
Right.
And I'll come back to where we are. Just above that paragraph, we set out the Bedica principles, the Buckhazen principles, and in particular, what are the informative pillars against which...
Isn't Bedica the latest statement by the Constitutional Court on this whole subject?
It is. It is, my Lord. And in fact, the question that your Lordship is asking me is the sixth of those pillars. Sixth, abstract values such as Ubuntu, reasonableness, and fairness do not provide a freestanding basis upon which a court may interfere in contractual relationships. Because they, however, perform creative, informative, and controlling functions in that they underlie and perform the substantive law of contract and should be used by the courts to draw normative impetus and develop new doctrines to address deficiencies in the law of contract. It is only where a contractual term or its enforcement is so unfair, unreasonable, or unjust that it is contrary to public policy that a court may refuse to enforce it. So, my Lord, the discipline, as your Lordship correctly asked, would your Lordship be entitled under these circumstances to invoke that principle? Basic point of departure. Is it pleaded? In other words, or is it simply being invoked in the abstract? Because if that is so, it does not, in and of itself, provide a self-standing basis upon which a court may interfere with contractual relationships. And if, my Lord, if I can refer to the fourth principle, which is at 23.4, to buttress the one in 23.6, that a party who attacks a contractual clause or its enforcement bears the onus to establish the facts. So there is no invocation of these principles in the abstract, my Lord. A party has to plead them. So you can't say, I have these conditions of service which embody my terms of contract, and, my Lord, you then say without more, what is it about the enforcement of those terms that implicates those principles? And it is worse in circumstances where you've had the full benefit of that contract. You took the contract, you did the job, my Lord, not indicating any unfairness in its implementation, or at least in what it provides for. And right at the end, my Lord, you come by way of a conclusion without pleading the facts as to why an enforcement of the contract on its plain terms invokes unfairness, reasonableness, justice, and Ubuntu, my Lord. That, with respect, is impermissible. And these issues, my Lord, that are raised in the founding affidavit by the applicant, the Speaker deals with them as we indicate in paragraph 19 of the note.
On this construction, the court will have to interpret vacation in clause 3.1 to include removal.
Correct.
However the removal came about.
Correct. my Lord, then those principles are set out therein. I'm trying, my Lord, to save time and afford Mr. Mpofu some space to do a reply. But your Lordship will find the 6 pillars of the Bidika principle. And
I've read the judgment. I'm familiar with it.
yes, my Lord. Then, my Lord, we reference. I'm moving now, my Lord, to paragraph 24 of the note, in which, in paragraph 160 of our heads, which your Lordship will find at P31-57. Well, we've referenced the decision of the Supreme Court of Appeal in AB versus Predwin Preparatory School. And, my Lord, we just wish to emphasize 2 additional principles to those that are articulated in Bidika. And in paragraph 160, we make the following point. In any event, at common law, contracts that were unconscionable, inimical, or incompatible with public interest were held to offend public policy. The interpretation of the service conditions by Advocate Mkhwebane creates that exact result. Furthermore, in her attack of the service conditions, she bears the onus to establish the facts upon which her attack is mounted. This, we submit, she has failed to do. This court can only use the power to invalidate the service conditions sparingly and only in the clearest of cases in which harm to the public is substantially incontestable and does not depend on the idiosyncratic inferences of a few judicial minds. A court should decline to use this power where a party relies directly on abstract values of fairness and reasonableness, as Advocate Mkhwebane does, to escape the consequences of a contract because they are, as the court describes them, not substantive rules that may be used to achieve that purpose. And then lastly, my Lord, in 162, the service conditions as they stand do not harm the public. And if I may just stop there, there is no showing also in the pleadings how they harm the public. But in fact, the enforcement of the service conditions as they stand, we say, protects the public from funding a gratuity of a public protector who was removed, which can only serve to threaten public confidence. So in other words, the enforcement of the conditions as is, as opposed to harming the public, it actually protects it from the consequences that would follow if one were to adopt the interpretation of the conditions of service in the manner contended for by the applicant. Lord, the question of discrimination and arbitrariness has been addressed by our learned friend. I'm not going to go there. If I can ask your Lordship to turn to paragraph 27 on page 13 of the note. This is where we deal with we deal with the contentions that are to be found in section E1 of the founding affidavit that deals with a declaration of unconstitutionality. Apologize, my Lord. Lord, we wish to emphasize, perhaps, or deal with this point. Under the second bullet, we say, in a nutshell, the applicant says, I'm going to skip the first point and over the page, my Lord, page 14. She says, denying her legitimately expected remuneration violates her right to dignity and self-worth. And my Lord, if I can just pause there and ask your Lordship to move ahead of the note to page 16. We address principles of legitimate expectation, commencing in paragraph 30. And my Lord, commencing in 31, it is tried that a legitimate expectation may arise either from an express promise given on behalf of the public authority or from the existence of a regular practice which the claimant can reasonably expect to continue. And if I can pause there, Lord, and apply those two principles to the fact. In order for your Lordship to find for the applicant on the basis of this leg of a legitimate expectation, your Lordship would have to ask himself two questions. Was there an express promise that was made to the applicant that she will be rewarded by way of a gratuity in circumstances where she would disregard the constitutional injunctions of upholding the constitutional standard, given that she is a constitutional institution, as it were, or she occupies that office in that capacity?
Can a public office bearer claim legitimate expectation? The expression generally is in the employment context.
Correct. Correct, Lord.
But the question, the court is asking the question whether
is it competent?
Whether a public office bearer, a judge, for example, judges are public office bearers themselves.
Your Lordship will recall we're making the point at two levels. The first point is we don't accept that there is a constitutional, there is a lawful invocation of the constitutional rights upon which the applicant seeks to bolster a declaration of constitutional invalidity. We've made that point. But assuming that your Lordship were to be minded, in other words, to get beyond that first question that your Lordship is asking, whether is it competent for a public bearer to invoke a legitimate expectation, my Lord? On the face of it, it does not seem competent. But my Lord, on a belt and braces approach, and your Lordship would understand a belt and braces approach for other reasons, Lord, that appear outside the pleadings, which is the following, that even on the assumption that it could be relied upon by a public bearer, there is a deficiency in pleadings.
So however, the issue, I understand the submission to be that assuming that it is available either way, it is not pleaded.
It's not pleaded because you've got to say there was an express promise that was made by whom, when, that I will be paid a gratuity, regardless whether I'm going to be incompetent, I'm going to be dishonest, I'm going to lie to judges, I'm not going to execute the constitutional standard that is imposed upon me. There's no such a case that's pleaded. And then you get to the second part. Is there a practice where such conduct, or it is the existence of a regular practice by which the applicant can can reasonably expect to continue? You've been told by the first and second respondents that this is the first time that this has ever happened. In respect of the public protectors who occupied this office before the applicant did, no one amongst them was removed from office on the basis of misconduct and incompetence and was paid a gratuity. So at those two levels, that aspect of legitimate expectation even if not pleaded, my lord, even if one wants to read it benevolently, it is simply unavailable. The second that we deal with, Lord, is, and in fact, this is the point we make in paragraph 33, that it is not surprising that the above jurisdictional prerequisites have not been pleaded because none exist. Then, my lord, we refer to the well-known Zemensky decision by Cameron J.A. When he was still sitting in the Supreme Court of Appeal. Writing for the unanimous court, Lord, Cameron J.A. reiterated the principle that subjective confusion or misinterpretation cannot give rise to a legitimate expectation. So if your contract, if your conditions of service do not stipulate that you will be paid a gratuity when you are removed on the basis of a constitutional injunction or standard that's prescribed in section 1941A. If you read it, my lord, resulting in a misinterpretation of your contract, that cannot ground a legitimate expectation. So, my lord, on either basis, either on the first two principles or even on the construction that's stipulated by His Lordship Justice Cameron, subjective confusion or misinterpretation does not ground such a claim. Then if I can just ask your Lordship to turn back then to the note, go back, so if I can just ask your Lordship to turn back to page 14 of the note. The fifth point. My lord, your Lordship saw there is an attempt to draw a comparison between a president, judges, and the public protector. What we have done, my lord, in the heads, and in fact, it's also in paragraph 67.6 of the answering affidavit. Oh, sorry, my lord. Sorry, this is the founding affidavit. I apologize. This is where the applicant, with reference to section 89, 177, and 194, speaks about a forfeiture, the concept of a forfeiture. My lord, the one answer before even one undertakes that legislative comparison, it is this, that you've got to forfeit that which is available in the hands of the claimant or the applicant in this case. You cannot forfeit that which did not lawfully vest on that particular individual. Put differently, absent vesting, Lord, there can be no forfeiture because there's nothing to forfeit. And in the premises, my lord, an attempt to bolster that argument of a forfeiture with reference to section 189 and section 177 of the Constitution to bring it within the prism of 194 is unhelpful because it yields the same outcome. If the entry point is there any vesting? And if that question has to be answered in the negative, the exercise is then unavailable because superficially attractive as it may be, it is not one that this applicant can take advantage of. Flawed as it is, because what we've also done, my lord, is this, that in the heads of argument, and this we set out in paragraph 28 before I deal with the paragraphs that precede it, so that we conclude that point, my lord. We say in the heads of argument, we set out a comparative analysis, which is comprehensive, my lord, between the impeachment of a president, a judge, and a public protector to illustrate that the forfeiture of a benefit in circumstances of an impeachment of a removal where one would be found to exist, because we don't accept that there is. But, my Lord, if what has happened here fits within the definition of an impeachment, of a forfeiture, then, my Lord, that result would be constitutionally permissible for the reasons that we've already advanced. So at two levels. One, the notion of forfeiture does not arise. But if, my Lord, linguistically it can be found to apply in this case, either as defined by the applicant or at all.
What would be the basis for the forfeiture? Would that be because, assuming that there was a vesting,
yes.
What would be the basis for a forfeiture? I assume that would be a consequence of the Section 194 process.
194, yes. That would be that. Yes. In that normative scheme, yes. My Lord, just to make the point, we've given Your Lordship the references of where Your Lordship finds that analysis in our heads of argument. It's in footnote 37, where Your Lordship would find that comprehensive comparative analysis. 2 points just to make for Your Lordship to bear in mind when Your Lordship has regard to that comparative analysis, if Your Lordship deems it necessary to get there. It is the following. One, a gratuity is defined in the Judge's Remuneration Act, my Lord. And it stipulates a qualification criteria that is linked to active service. That's the second point. The third point, Your Lordship will find that there is no textual or even linguistic support that that act yields an outcome that a judge who is discharged on account of incompetence and misconduct would qualify for a gratuity. And again, my Lord, it's purely for belts and braces. On the pleaded case and on first principles of interpretation, one does not even need to get there. Then, my Lord, again on page 15 of the note, when we deal with the argument of discrimination and arbitrariness, you know, from a different angle from the argument that has already been presented, Lord, we say the following, and I'm looking at the point just above paragraph 28. Apart from the fact that the applicant has failed to establish that any of her constitutional rights have been limited, in the event that such limitation occurred, it is reasonable and justifiable under a law of general application, and further that any limitation imposed by the conditions of service would also be properly related to the purpose they seek to achieve, there being a logical relationship between the purpose sought to be achieved by the provision and the means used.
What would be that law of general application on this construction?
In this construction, Lord, one would have to assume that the law would be the contract itself.
No, but then that can't be a law of general
let
application.
me unpack. Because Your Lordship will recall, you start from the contract and then you go to the Public Protector Act. If Your Lordship recalls, Section 2.2 and Section 2.3, that's where it deals with the conditions of service, but none give expression to a gratuity in circumstances such as the following. So, and I take Your Lordship's point. So, your legislation in this case would be the Public Protector Act, because on the applicant's construction, and I don't think there's a controversy on that, the conditions of service constitute a contract. So one would have to look at the circumstances in which the law of general application prescribes no constitutional injunction to pay a gratuity in circumstances of a misconduct
Yes,
or
except-
incompetence.
Except the Public Protectors Act is silent on the subject.
Yes, my lord.
So it can't be a prison for considering what the law of general application may or may not do.
Yes, sir. My lord, if we get, you recall one of the things that one of the submission that was made to your lordship was that, in fact, none of these respondents perform a limitation exercise in terms of Section 36. And perhaps, my lord, on reflection of the question that your lordship is asking me, let me take 2 steps back and make the following submission. If your starting point is that this is purely a contractual dispute that has been lawfully concluded, and all that your lordship has to do is applying the contract using the ordinary principles of interpretation,
But is a Section 36 analysis
does not even
competent
arise
in relation to a contract?
Yes, my lord. That's why, no, I was going to make the point that it then does not arise. And my lord, the issue of whether a Section 36 analysis even needs to be performed at all, it does not even arise. In other words, it ought not to on the facts of this case. Your lordship will recall, yesterday your lordship asked the question, what is the nature of this, what is the nature of the service conditions? And we said, my lord, in fact, that is also my recollection, that the answer that was given is different from the pleaded case, because the answer was, it is a statute. And that is why our learned friend, on behalf of the first and second respondent, addressed that issue at length this morning. So,
I don't quite recall that as the answer. My recollection was that it was a confirmation that it was a matter of contract. A matter of contract, having its derivation from the basic condition of employment act.
my lord, then if that's the case, then this controversy does not arise. We probably, in preparing the note, predicated it on the assumption, and probably mishearing the response that was given to your lordship, because
no, the case made was that the conditions of service are to be construed as a matter of contract.
my lord, if that's the case, then this submission is premised on mishearing the response that our learned friend provided to your lordship. And then, my lord, if we are purely in the realm of contract, your lordship is quite correct. The Section 36 analysis does not arise. Then, my lord, in paragraph, on page 17, we deal with the last bullet, section E4, which are the alleged breaches and specific performance. The point, Lord, that we wish to make is where we started. And it is to provide your lordship with the portion of the pleadings where the question of the communication of a decision is the communication of the consequence that flows from the proper implementation of a contract and not being a decision, Lord. And that your lordship will find, it's the third bullet from the bottom. The reference is the answering affidavit at page P02-88 at paragraphs 154 to 156.
Mr. Mtau,
Yes, Lord.
what is the court to make of the view by the speaker in the light of the fact that the public protector accepts that she made a decision?
Lord, as your Lordship would know, whether a decision has been made or not, it is a question of construction by your Lordship.
Well, I mean, the primary person here, as far as why this court is sitting, is the applicant saying that the public protector took a decision not to pay a gratuity, and that is how she's come to court. So it seems to me that it doesn't matter what any other person says.
Lord, two things. One is on whichever construction, Lord, let me not be head to mean perhaps a different outcome is reached depending on the route that one takes. Even on the assumption, Lord, that a decision had been made, it would not change the Speaker's approach on the principles that inform, one, the proper interpretation of the contract.
Well,
one.
yes, that will be an entirely different
argument.
But to put forward a case that there is no decision when there is a litigant before court saying that I took a decision, that seems untenable.
Lord, well, let me get to the second point. The second point is this, that if your Lordship has regard to, and in fact to answer the question, your Lordship will have regard to the conditions of service and whether the conditions of service lend themselves to an interpretation that permits the exercise of a discretion on the part of the public protector. Because if it permits of the exercise of a discretion, Lord, then it is that discretion that must be applied and a decision reached.
But still, that doesn't matter because she says, I made a decision.
My Lord, we've made the submission and we don't abandon the submission, Lord. I don't have to, well, I'm not, or don't intend, Lord, to press it any further or push it any further or take it beyond the point that if as a matter of legal construct, Lord, if one takes the expression a rose by any other name, is still a rose. Whether, my Lord, it is a rose, your Lordship will have to determine with reference to the features of what does a rose.
No, the court can't go outside an assertion by the public protector that she took a decision. What the court what the court can and should do is to examine the consequences in law of the taking of that decision.
My Lord, I take your Lordship's or note your Lordship's point, and we've made the submission as expressed in the answering affidavit, as expressed in the heads, my Lord, and we don't take it further. But let us, my Lord, not be understood to be abandoning the submission that when you are interpreting a contract and simply saying to someone the conditions of service do not contain a category entitling you to the payment of a gratuity where you have been removed through misconduct and incompetence. Lord, whether that in doing so you are communicating the outcome that is prescribed by the contract or you're exercising a discretion. That's where we will leave the...
Yes. I mean, the further aspect, of course, is this, that the Speaker, when she was asked through her office to give advice, replied by saying that the National Assembly detailed the conditions of service, we have no further business. So that being the formal position that was communicated to the public protector, the Speaker now can't be seen to now want to advance a position as to whether or not there was a decision or no decision.
Manoj, perhaps it's a question of inelegance on my part. This is the point that I'm making, and in fact the Speaker's pleaded case, which does not detract from any of the submissions that have been made. Your Lordship will have a look at what the principles regarding the exercise of a discretion in the communication of a decision entail. If they leave themselves, if the facts of the case yield an outcome that in deciding whether to pay a gratuity or not, there is an element of the exercise of a discretion, then, my Lord, there is a decision.
The court can't accept that submission. And fundamentally, the case is, I took a decision. I really do not understand why the Speaker seems to want to press the fact that there was a communication of an aspect or another when one of the key litigants says, I took a decision, and the applicant says that decision is wrong in law.
Yes, no, I take the point, and for purposes of resolving this dispute, it is immaterial, Lord. Let me put it no higher than that. It is immaterial whether your Lordship does that through the prism of the existence of a decision which the Public Protector says she took, and, my Lord, without having regard to the primary, well, let me put it this way, the first construction that's offered by the Speaker, that this is a mere communication of what would follow as a consequence. So in other words, it is not central.
Forgive me. That amounts to the Speaker giving advice on the Speaker's view of what the conditions of service are about. But I mean, as I understand the papers, the Speaker is at somewhat of a remove. There is a bit of a distance on the issues as regards whether or not the applicant is entitled to a gratuity, because in the papers the Speaker says this is what the National Assembly had to do in terms of the Act. We did that, and we did that which the law said we must do. I mean, what other
and
what other interest might the Speaker have?
Your Lordship would have seen from the remedies that are sought.
Well, apart from the formally the relief that is sought against the Speaker, but that is a matter of pleading.
Well, my Lord, I don't want to have to detain your Lordship on this point, because it's not a live controversy for purposes of...
Well, that's what puzzles the court, because the court ought not to have to examine or put to counsel that one of the primary litigants says that she took a decision, and the applicant says that decision was wrong in law, and a person at the remove says, well, that wasn't a decision.
My Lord, perhaps let me try and reformulate the submission on the following basis. It is unnecessary, my Lord, for purposes of the determination of this case, and that is why I was saying it is not an aspect on which the matter turns. And following that, my Lord, there is no utility in, it is for purposes of your Lordship's decision making, in me insisting that this is either a decision or it isn't. And the reason why I'm raising that, Lord, it is because there are other bases upon which the relief is being sought, including striking down, etc., etc.
Yeah, that's something
yes.
different.
No. If I may just complete this. Your Lordship will know you often find or come across matters where perhaps there are 5 points that arise. And
this doesn't seem to be a good point for the Speaker.
My Lord, let me let me, for purposes of progress, so that we can reach the conclusion, because in our submission, all roads lead to Rome. And for us to be detained on the basis of whether what this that has occurred is a decision or not, in the postulation of the example that I was trying to put earlier, if there are 5 points that arise in a matter, and the matter can be resolved either on 1 or 2 points, one does not need to even reach the determination of the third, the fourth, and the fifth. And this classification of the communication by the speaker is not one of those that is primary for purposes of your lordship having to make a determination. In other words, it doesn't stand in the way that requires a resolution on the part of your lordship, because his lordship would still have to look at the other remedies in which the speaker clearly has an interest and its processes.
Yes, then we will hear the other ones.
Yes, my lord, and we've made our submissions in respect of the others. I was about to conclude just by giving your lordship that reference. So I made the submission earlier regarding the principles on this point. And what I was doing was to give your lordship the pleadings of where in the answering affidavit your lordship will find that. But my lord, I'm not, it's not one of those matters that is a matter of life and death that I need to carry with me and to seek to persuade your lordship to agree one way or the other about the classification. Because if one has to subject that through the prism of utility, is it a necessary ingredient to sustain the speaker's case that no proper case has been made out and this application should be dismissed, for the speaker to have to persuade your lordship whether this is a decision or it isn't? Lord, it's not one of those. And for that reason, your lordship can reach the conclusion without even endorsing or upholding the speaker's contention for purposes of the judgment. That was more the point, my lord, that I'm trying to make. If it's one that I needed, my lord, would have had to spend some time to say, without this, all my cards fall.
You actually seem to have spent more time on this point.
No, but other than the earlier part, my lord, all I was doing here, my lord, barring your lordship's question, and I'm not saying your lordship is not entitled to ask me, I had already addressed this issue much earlier. All I was doing, my lord, was, by the way, that point, if your lordship is looking at it, this is where your lordship finds it in the answering affidavit. That was going to be the upshot of it. If I had known, my lord, I would not even have given your lordship the reference, because I'd covered that issue. But, my lord, such is the purpose of engagement. My lord, if we can conclude, we've already dealt with the question of costs earlier on. We've dealt with why it is that a constitutional matter must be determined from the pleadings, whether it is one or not. In other words, dressing it up as a constitutional matter does not qualify. And in fact, I think the first and second respondents cite the well-known decisions in that regard in their section of the heads that deal with cost. That's that we find application herein. Lord, we say, if one concludes by asking questions by way of a scheme, these questions, which are rhetorical, my lord, we wish to add, illustrate the lack of merit in the applicant's case. And my lord, simple and elementary as they may be, we would suggest that they would somehow be informative in terms of how one resolves this dispute. And my lord, the first question would be, following the submissions that were made, how does the institution of the public protector get established? We're not answering the question because it is rhetorical. The second is there any national legislation that governs that institution? The third is, once a public protector has been appointed, does she or he have a contract of employment? And if so, and more specifically, for purposes of this case, does the contract of employment make provision for the payment of a gratuity? And if it does such employment contract stipulate an eligibility or qualifying criteria for such gratuity? Because, my lord, that will be important in answering the question of whether there's a forfeiture. If it does such qualifying or eligibility criteria include payment of a gratuity in the event of the removal of a public protector by way of Section 194 for incompetence or misconduct? What legal instrument authorizes the removal of a public protector? And if so, what does it say are the preconditions that should be met for purposes of removing the public protector? Are those two notions that are stipulated defined in the rules of the National Assembly? In other words, the meaning of misconduct and the meaning of incompetence? Does the legal instrument that authorizes the removal of a public protector sanction the payment of a gratuity? Does the Constitution sanction accountability as a standard that applies to the public protector? And if so, as part of this standard of accountability, does the Constitution sanction a removal of an incumbent from office in circumstances such as the one or the ones that are applicable to the applicant? And does even the concept of forfeiture of benefits arise in circumstances where there was no vesting? If the constitutional standard of accountability applies, as we've shown with reference to the cases, does it apply to the public protector? Would a removal from office of a public protector on grounds of misconduct and incompetence, which are stipulated in the Constitution, without payment of a gratuity, be consistent or inconsistent with the Constitution? My Lord, we submit the answer to all of those questions. Go back to the submissions that were made, and each of those answers, Your Lordship, we submit will find that they are, as I indicated, rhetorical, because those answers will illustrate to Your Lordship why such a claim is not competent. Lord, unless there's anything else that Your Lordship wishes me to address, those are submissions.
Yes, thank you. Is there any reply?
Well, there's that process of removal that has to take place.
If I could just go to the bathroom whilst the musical chairs are being played.
Thank you, my Lord. My Lord, because I do not have time to reply, I propose, one of the things I propose to do, and that is in a way prompted by the last half an hour, is really not to address much of what the speaker has to say. Because in our respectful submissions, the involvement of the speaker in this matter adds no value at all. It has no bearing. In fact, it's puzzling why any speaker would oppose a matter such as this one, instead of, if they wanted to assist the court, maybe file an explanatory affidavit giving context, as they usually do. But to be involved combatively in this matter is completely inappropriate for the speaker, particularly if one of the contributions is to, as the Lordship pointed out, to second guess the actual decision maker who says, I made a decision, and the speaker comes here to say, I didn't make a decision. And the irony, of course, is that the decision to oppose this matter was taken by the previous speaker, who herself has resigned and probably got a gratuity after facing criminal charges. And the current one has obviously decided to continue with the case. So we will not address anything really that's been said by the speaker, which does not overlap with what Mr. Mkhwebane has addressed, for that reason. It's really ironical as well for people who are complaining about misconduct and waste of taxpayers' money in litigation and so on by the former public protector to engage in this kind of joyride. But my Lord, because there's no time, let me start in the following way. I've heard things today which I've never thought I was going to hear. One of them being that a case that involves Section 194 and the impeachment of a Chapter 9 institution and all those issues is not a constitutional matter, which, according to Mr. Mkhwebane, involves a standard of constitutional accountability. That is not a constitutional matter. But let me just say this so that if I run out of time, at least I would have said as much. One of the key issues that has not been addressed by either Mr. Mkhwebane or Mr. Mkhwebane is the crucial issue of the failure to furnish reasons. Nobody has addressed this at all. At least Mr. Mkhwebane has addressed it in a way that is at least incomplete, let me put it that way, because he says something that is puzzling, but in another context. He says that reasons which clearly say that any removal under Section 194 is a basis for the forfeiture. Those are the reasons that Your Lordship would find in the 12th February letter, are exactly the same as reasons which say that the forfeiture is only confined to misconduct and incompetence. I mean, have you ever heard of anything like that? How can it be that a set of reasons which include a removal under Section 194 for incapacity is exactly the same thing as another set of reasons pleaded in the answering affidavit which exclude a removal under Section 194. My mind can't even work itself around that. But be that as it may, the issue that has been raised is that And Your Lordship, for the sake of shorthand, if Your Lordship, I'll refer Your Lordship to the Hoekstra, page 656, which the heading is 8.6. It says reasons under the principle of legality. And one of the cases quoted there says the principle of legality, which includes rationality and accountability, imposes a duty upon the functionary exercising a public power to provide reasons for its decision. And then later on it talks about JSC Cape Bar Council case, which says the court required reasons as a matter of rationality, and more specifically as a way of demonstrating rationality, rather than as an independent requirement of the legality principle, and so on. Then, so the criticism that we have leveled against both parties, at least the public protector, for inadequate reasons or reasons that change all the time, but in the case of the speaker, no reasons at all, has not been addressed by any of their counsel. But that's a key.
The speaker will give reasons for what?
Well, for what is in the notice of motion, which I read out yesterday, which said, insofar as in terms of Rule 53(1)(b), we said all those respondents, including the presidents, insofar as and the Minister of Finance or whoever is cited, insofar as they may have played any role in the decision, should give us, one, a record and reasons. And they failed to do so. They simply rocked up in court and basically said nothing. So the reasons are important for two reasons, if you excuse the tautology. They are there. As I say, as a matter of rationality, and also as a matter of what we called yesterday ex post facto rationalization of a bad decision. Now, what is the bad decision? The bad decision is the one that includes incapacity, which is in the letter. What is the ex post facto one? It's the one that excludes incapacity. Those are two worlds apart, and to try and argue that they are the same thing is the most amazing thing I've ever heard in my life. Mr. Ngwaitobi, now I'm still using this issue of incapacity, but for a different purpose. Makes another startling submission, my lord. He says that incapacity is a ground for vacation of office. And he says that in reference to Section 2.2 of the Public Protector Act. The Lordship will remember that Section 2.2 refers, among other things, to vacation of office as a result of ill health, which Mr. Ngwaitobi correctly says that amounts to incapacity. So, again, maybe it's my simple mind. If incapacity can be a ground for vacation, or rather can be part of the vacation of office, and incapacity can also be a ground for the removal of a public protector in terms of Section 194, then how can then you say that a removal that includes incapacity is excluded from the definition of vacation? That's just plain nonsense. It doesn't make sense at all. It's just logical myopia. Because if Mr. Ngwaitobi is correct, he gave us four categories of what he says includes vacation of office. It's incapacity, death, resignation, and a fraction of time. Now, if he's right in that that those things are subsumed under the rubric of vacation, then surely the question must arise as to why they then said in their letter of reasons that the real reason for the forfeiture clause that they were applying is any removal under section 194, and I'm using the word any. It's my own word, but that's the reading of that letter. So let's put that aside. But that just shows again the absurdity of these arguments that are being put here. Then Mr. Ngwetobi says, "My Lord, I'm prepared to work on the basis that gratuity is a benefit. And even if that is so, the case should be dismissed." But again, how do you say that? Because if the gratuity is a benefit which is provided for in so many words in section 2195 of the Constitution, which is provided for in the Public Protector Act, section 22, and therefore finds itself in the service condition provisions in that flow that I traced yesterday.
Mr. Mpofu, when you submit that gratuity, provision is made for gratuity in the Constitution,
yes,
is that in relation to the Public Protector?
Yes. 2195 says, my Lord, that that the remember we're talking about benefit now.
Well, no, I mean, the law derives its life from words, so unless it's agreed that gratuity is the same thing as benefit, then that's something
No,
else.
but my Lord, that's what I've just said to you, that Mr. Ngwetobi, this whole submission is based on the concession that gratuity made by Mr. Ngwetobi, that gratuity may include that a benefit, a gratuity may be a benefit.
So on that construction.
Yes, that's the only thing I'm addressing. Yeah. So the point I'm simply making, a constitution is just a framework. It cannot contain everything under the sun. It can't say medical aid, this, that, and the other. It simply says it says remuneration, salary, allowances, benefits, but it can't list all of them. So under allowances, you might have motor car allowance, You can't say where is it in the Constitution. It's subsumed in that way. In the same way that all benefits would be subsumed under the word gratuity on this aspect that we're discussing. But one cannot ask where is it in the Constitution. Let me do it like this, my Lord. We've given Your Lordship 4 specific reasons why a gratuity is part of remuneration. We have said that I think I used the word parentage of the service conditions comes from section 22 of the Public Protector Act, which deals with remuneration. That section itself comes from section 215 of the Public Protector Act, which deals with remuneration. The gratuities referred to in the Judges Remuneration Act are also, obviously, because of the name of the Act, part of remuneration. The section 32.3 of the definition of remuneration in the BCEA also encompasses remuneration.
Yes, I do recall this made yesterday.
Yes. So I was hoping, so I don't want to go back there. Assume that I'm talking about that. That's the relationship between the gratuity and the remuneration. But I'm saying, I'm taking it further. I did yesterday by saying it's obviously not salary, it's not allowances, it's a benefit. Now, my Lord, if you don't believe that you can go to section 35.5 of the BCEA. Section 35.5 talks about severance pay and all that jazz. And it says that for the purposes of calculating of that type of payment, remuneration shall include the cash portion. I'm paraphrasing because we don't have time. Shall include the cash portion and any payment in kind and so on, but exclude gratuities and allowances. In other words, that section would not be there if it's a specific section that excludes gratuities for the purposes of severance pay or whatever. Without that section, it's because the drafters of that act knew that without that section, that subsection or that exclusion, gratuities would be owed to the person who gets paid severance pay. So that's a fifth reason. But Your Lordship will do with that as on the other side of the scale, nobody has said anything. I've given those 5 indicia which are clear from the text of those instruments. Nobody has shown you anything except some case to do with taxation that says that the gratuity must be excluded from remuneration. What I don't understand, my Lord, is how gratuity would find itself in these service conditions if it was not remuneration. What would it be doing there? Because those service conditions are only deal with remuneration, but different aspects of it. Mr. Mkhwebane says that the heading in the service conditions is gratuity. No. The heading in the service conditions is conditions of service for the public protector. That's the heading. In other words, it's the employment contract. And all we're saying really...
I believe he was referring to clause 3.
Well, but okay. Well, the real heading of that thing is service conditions, which means the conditions of employment. And all I want to say, my Lord, is that the way to read that whole document is that the public protector, that's the part that's not there, the public protector shall be entitled to the following. Then says 1, salary, 2, allowances, 3, gratuity, 4, this, that, and the other. That's the obvious interpretational context of that document. And the Lordship has asked the real only question, or at least Mr. Mkhwebane considered it after understanding that Welsh doesn't assist, to say what I was saying yesterday, which is that there are brands of gratuities. There may be those that, like a tip and so on, which was ascribed to me for some reason. There may be those that are just favors. Yeah. But the brand of gratuity we're talking about here is the same brand that you will find in the Judges Remuneration Act. It's the same brand that you'll find in the GEPF cases. Buitendag, your Lordship referred us to Buitendag. That's the brand we're talking about here. The brand which is an legal obligation and entitlement. Well, how do we know that, my Lord? We know it because if you look at Buitendag, the case your Lordship brought to our attention, the reason why the court found there that the children were entitled to that gratuity was because, if you look, I can't remember which paragraph it is, but the clause itself, I think it's paragraph 9 or something. The clause itself says, upon the death of the dependents shall be paid this amount. So obviously that's a legal obligation that arises. If it said maybe may be paid at somebody's whim, that would be different. So the legal obligation characteristic of that comes from the use of the word shall. Similarly, in the judges, in section 11 of the Judges Remuneration Act, where it says the gratuity shall be paid, That's why it's a brand that becomes a legal obligation.
Except there is no equivalent for the public protector.
There is. There
in
is.
Which statute?
So, 3.2 of the.
Well, I understood you. Forgive me. I understood you to be saying that the Judges Remuneration Act expressly refers to a gratuity in relation to adjourns.
Yes, but I'm saying the force. I'm saying the force. What do you call it? The obligatory force of that clause comes from the word shall. So whether the word shall is the word shall, whether it's found in this instrument or another, and I'm saying that in the fortunately that is exactly the same word which is used in 3.2 of the service conditions, which Your Lordship maybe has forgotten. I'll just refer. You'll find that 012-185, and I did say this yesterday. Just like in the GEPF case, 3.2 says the surviving spouse who died before his or her term expired shall be paid an amount equal to the gratuity, which would in terms of not died. But anyway, we've explained that. So and Mr. Ngwaitobi is reading the 3.2 wrongly. The only deeming thing in 3.2 is about the 4 years. But he says it deems the death or something. I can't remember the expression he used. No. The only thing that is deeming about that provision is factor E, which becomes 4. But the rest of it there's no logical way out of that corner, my lord, which is that you either confine vacation to voluntary acts, but if you do that, then you say, what is death doing there? Or you accept that there are involuntary acts such as death, such as removal for incapacity, as Mr. Ngwaitobi did, both of those are involuntary acts, and he accepts that those things are part of vacation of office. Now, if you do that on any logical basis, you can then, in the same breath, argue that there is no such thing as an involuntary vacation. In other words, one that is imposed on you either by nature or by Parliament. So the arguments are just circuitous and completely illogical, which then takes us to the 811. How can you say, the same person says vacation of office includes, or at least let me not put it higher, may include an involuntary removal, or one that is triggered by that at least. But in the same breath, you say that the list in 8.11 is not tautologous. You say yourself that death is one of the 4 things that can create a vacation. And you go to 811, which you'll find at 2 pages later, and it says vacation of his office, of his or her office, which on your own interpretation includes death. And then and the next one, Roman, it says the death of the public protector. So that means on your own version, death has been mentioned twice. What then is the meaning of tautology? Tautology means mentioning the same thing twice. So how can that clause, which is tautologous in respect of death by any interpretation, but suddenly it's not tautologous when it comes to removal from office? Honestly. So the issue is this, my lord. And the case of African, the case of Mpati J does not assist Mr. Ngqobaitobi at all.
Which case?
That is African Products. It was handed up to you, my lord, I think. African Products Pty Ltd versus AIG South Africa Ltd 2009-3 SA 473. That case is authority for the proposition which was read out by Mr. Ngqobaitobi in paragraph 13, which says that where the conjunctive and is used, you must assume that the legislature wanted to give meaning to both. In other words, if it says it's A and B, you can't just say, well, the B was superfluous. But that's a different thing where the conjunctive or is used, which is what you'll find in 8.11, which says on removal from office, vacation from office, or the death of the public protector, his or her effects may be transported. So that case doesn't, if anything, it assists the opposite contention, that it's more likely to be tautologized if you are listing things of the same kind or the same genus or type or species or whatever you call it. And so paragraph 13, yeah, since the words unforeseen and sudden are joined by the conjunctive and, the physical damage to the cables must have been both unforeseen and sudden. That's really the essence of what Party J was saying in that case. Probably Party J A. I don't know why it says Party J here, because it's an SCA case. But be that as it may. Then, my lord, we are so the issue of the moving target reasons is not addressed, and the issue of the vacation and or rather the linkage of gratuity to remuneration is dodged, and then this issue of the broader definition of vacation is effectively considered by giving those four categories, which includes involuntary, quote unquote. Because remember, the case here was that vacation of office is something you cannot do except out of your own volition. So unless if you die of your own volition or you get removed of your own volition, then the case is, that's the end of the case that we were told is the reason why there's a forfeiture clause. It dies right there. Anyway, let's then go to the very quickly to the issue of organ of state. That whole thing about definition, whether it's administrative action. My Lord, I beg you to hand up. That's the one where I wrote. Yeah. If your Lordship, this is a case of Sunpax versus MTO. If your Lordship doesn't mind, I've scribbled the...
As long as you didn't record your admonishment of the court in the judgment.
Today?
You're admonishing the court.
In this judgment?
In that document, then I can read it.
No, how, my Lord? Did I was not even involved.
No, I was merely reflecting that you had made notes, and I was...
Oh, yes, so I mean, as long as it's not a strong admonition. I get it, my Lord. No, it's definitely not. That is just the SA law reports reference, which I found later because we had just printed it. Now I've lost it. It's 2018-5 something.
Yes, no, the citation is recorded on the document.
That's
yes.
all. That's all. Yes. I cannot show my learned friends. Yes. It reminds me of a story which I would tell if I had time. But that judgment, my Lord, says because there's no time, I will just paraphrase what the import of it is. It does away with this notion of the seven cardinal pillars or the seven what to call it, this thing, requirements of administrative action. The one that I said yesterday, I was not, for the sake of time, going to embark on, because it misconstrues a lot of things. At least we now know that a decision was taken, or at least
forgive me, some people, I don't quite understand.
Yes.
The reference to the 7 elements.
Yes.
To the
this matter.
To the question of whether or not one is dealing with administrative action.
Yes,
that was a statement by the Constitutional Court.
Yes, in Muta.
Now I hear you to submit that this decision does away with that. Did I understand you correctly?
No, you didn't understand me correctly.
All right. Well,
I'm saying, my lord, I'm saying that this decision will demonstrate to your lordship that 4 against 1, the majority of the courts, being Dambuza, J.A. Nafsa, Leach, J.J.A., and Davis, A.J.A., found that where the so-called contractual provision owes its existence from legislation, and in this case it's even better, as we said, even the Constitution. It assumes a public status, for lack of a better word. And I think Cameron J said that in another case. And therefore, it becomes administrative action for that purpose, because it is imbued with that public quality. And the dissenting judge, Rogers, AJA, as he was, differed with the majority and went on the 7 pillars, all 7 of them. And he went in terms of any legislation,
well, I mean,
and so on and so on.
The dissent is not the decision of the court.
No, but that's exactly the point I'm making. That that approach, which has been sponsored here, was defeated in this case.
No, that doesn't make sense. I don't
all
understand.
right.
No. Forgive me, Mr. Mpel.
Okay.
I mean, the submission is important to you, but I have to understand it. First, I thought you had said to the court that the 7 elements were done away with by the Supreme Court of Appeal. I then said, but the requirements were a statement by the Constitutional Court.
Yeah.
And then you said, well, the decision was actually about a contract that derives from statute, assumes a public character, and so forth.
Yes.
But then you go back to the dissent, repeating the 7 variables, and then you say, well, that was a dissent. So I'm a bit confused as to what
I will not confuse your lordship any further. Your lordship will read the document at your own time. My submission is simply this.
Mr. Mpofu, please. I have to understand what is the submission that you are making to the court as far as this decision is concerned.
I'll do it in one sentence, my lord. You have a decision binding upon you of the Supreme Court of Appeal, which, as I say, took, if you like, in the context of this case, there's me against them, as it were. So the position we take is that the contract is not just a contract between private parties, that it's a contract that by its nature and its genesis has assumed a public character. The other side argues that irrespective of that, one has to go through the 7 steps. And all I'm saying is I'm giving you a decision which where the majority went with our approach and theirs was in the minority. That's all really.
Except that wasn't the issue, because the issue was what is the nature of administrative action. Forgive me, Mr. Mpofu. You do have to listen to the court. The issue of the 7 elements arose. arose in the
I'm
context.
listening, my lord. I'm not being
Yes.
disrespectful. I'm just. Yes,
The
ma'am.
issue of the 7 elements arose in the context of the need by a litigant to establish whether or not one is dealing with administrative action. That is the only context to
Yes.
the reference to the 7 elements.
Yes. Ma-
That
sorry, ma'am.
wasn't about whether or not a contract arose from legislation and for that reason
Okay.
assumed a public character.
Okay, my lord.
But I understand the
That-
purpose of this
Yes,
submission.
yes, my lord. Okay. But by the way, that's the same issue in the case I've just given you, was whether it's administrative action or not. And for the reasons that have been debated here for the past 2 days. All I'm saying is that here's a case which went the one way as opposed to the other. That's all. I know the issue is what we've been debating. I'm simply saying there's an additional authority which I'm offering to your lordship where those two contending approaches were put and our approach was upheld 4-1. But let me do it the hard way maybe. If we go to, let's go to the definition then. Because the definition doesn't really come from the Constitutional Court. It comes from even a higher place, as it were, from the legislation, the PAJA itself. But the point is, how must it be approached? Your Lordship asked me yesterday, and let me do this just as a shortcut again. Unfortunately, the shortcuts are backfiring. But here's the shortcut, my lord. Mr. Ngqobaitobi went on a long trip to say to you that the first part of organ of state exercising a power in terms of the Constitution doesn't apply, and that's it. Well, that's completely wrong, my lord. The proper question is the one that your lordship asked yesterday. Firstly, that's a wrong statement, and I answered that question yesterday. But even if it was a correct statement, it means there is a misunderstanding of the role of empowering provision in this debate. Because Mr. Ngqobaitobi says, well, empowering provision doesn't even feature because we are dealing only with an organ of state. Well, I just want at least to get credit for one thing. These cases of the public protector are cases that I've done for all the decisions that Mr. Ngqobaitobi referred to, the Cape Town ones and Concord ones, are matters that I specifically did. And in all those matters, the reason you cite the parties like the way we've cited them is exactly to overcome this problem. That's why you say the first applicant is the Office of the Public Protector, which in terms of Section 5 of the Public Protector Act is a juristic person, right? Then you say the second respondent, you either say it's the Public Protector or it's Kholeka Gcaleka or it's Busisiwe Mkhwebane, depending on whoever it is. But when you describe the party in the document, you then say they have been cited in their capacity, official capacity as the Public Protector, the institution, or rather the person, because it says a man or a woman. And also in their personal capacity if you want personal costs against them. It is that simple. In other words, you have your respondents are both the juristic person and the organ of state. And that's why I'm simply saying your lordship was asking the correct question. That, okay, even assuming that the only person in front of you was the juristic person, then where's the empowering provision? And we showed you the empowering provision is the service conditions, because empowering provision is defined in Section 1 of PAJA. It means a law, a rule of common law, customary law, or an agreement, instrument, or other document. Okay. So that would be the end of that whole discussion. Then, my lord, I just want. I'm just going with the bigger points so that it's your lordship. If at some stage I ran out of time, then I would have made these points.
Before we get to the next point,
Yes,
just drawing to your attention that the court is mindful of court officials.
Yes.
They don't sit the way that counsel do and
Yes.
judges should.
Yes.
So just be mindful of that in your further address, Mr.
Yes.
Mkhwebane.
Well, that's why I was going like this, my lord. I'm trying to. The other total confusion is around the role of Audi and or procedural irrationality. Total confusion. Let's start with Audi, as we all know it. Parties that come here, anybody, any labor lawyer or anybody interested in justice or fairness should shiver at the thought of somebody saying, we have a forfeiture clause, a penal clause, whose root is misconduct, really, and incompetence. Because even if it's transported from the other process, but really that's the root. So we have a punishment of a human being rooted in misconduct and incompetence, but there's no duty for a hearing. Oh, where have you ever heard such a thing? That you the very reason why you must have Audi alteram partem is either because you have a legitimate expectation, which you have pleaded, and or more importantly, that you are being punished, and I'm using that word loosely. So that's like saying you can just be sent to the gallows without a hearing. I mean, that's really what is being said. So that as I said, should offend the sensibilities of anyone interested in justice. But let's put that aside. You then, and my lord, no, let's not put it aside. Let me refer your lordship to the so-called impeachment case. It's EFF versus Speaker of Parliament. It's a case that I did. Mr. Ngwaitobi was in that matter with me. I think he was representing the EFF, and I was representing somebody else. Well, I'll talk while I'm looking for the notes.
You can mention to the court what it says.
Yes, I'll mention the principle. Your lordship will find it.
I will read it up again.
Yes, at paragraph 138 of that, it's EFF versus, it's a 2018 decision. I'll give you the citation. Oh, sorry. 2018 2 SA 571.
Which court? Okay.
CC, Constitutional Court. Sorry.
All right.
In that matter, my lord, Mr. Ngwaitobi and I went to the Constitutional Court with the following proposition. It cannot be, and successfully so, you cannot, if you're going to condemn in one way or another a person, in that case it was a president, and impeach them, it's impossible to do it without rules that include an inquiry and all that, a hearing for short. And the Constitutional Court agreed with us, and one of the reasons it said, it says, and it made a distinction between motion of no confidence, which is a no-fault kind of removal, and an impeachment. And it says the reason why it agreed with us was the reason for this distinction in process is that impeachment is punitive. Depending on the ground on which it is based, the impeached president may lose all benefits and be barred from occupying any public office. In other words, that right to a hearing was attracted exactly because of the forfeiture or even the possible forfeiture of benefits. You'll find, I think there's also paragraph 207 and then another series of paragraphs where your Lordship will find the same sentiment. But now we're told, 6 years later, that you can have your hearing for the actual impeachment, but for a vacation, termination, whatever you call it, which is triggered by that same impeachment, you don't deserve a hearing. It can't be. But let's put that aside. There's also procedural irrationality is completely misunderstood. Procedural irrationality says this, my lord, and this is what was said in Law Society, that its difference from, I think it was Mohuang CJ, its difference from Audi proper, as it were, is that it asks the following question: whether the process that was followed, well, in this case there was no process at all, so the inquiry would end there. But for what it's worth, it says whether the process that was followed is rationally linked to the objectives of the instrument. I'm paraphrasing. That's what is known as procedural irrationality. So in other words, the fact that the process might lack Audi is just one of the factors for its criticism and its assessment as to whether or not it amounts to irrationality. So we've pleaded two things, my lord, for obvious reasons. We've pleaded Audi, as we know it. We're pleading it as a standard of fairness, and the bar case and cases have no place here because those cases talk about contractual relationship between private parties. So we've pleaded it in that context, and we've also pleaded for a hearing under legitimate expectation, which is Section 3 of PAJA, and we've also, in case we're wrong on all those things and it's not administrative action, then we've pleaded procedural irrationality, which is a function of the legality review. So if your lordship finds no, you don't need a hearing, you can just have a forfeiture. No, legitimate expectation doesn't apply. No, it's not administrative action. Your lordship must still find that the process followed or not followed, for lack of a better word, in this case is irrational given the punitive nature of the consequence, and given what was said by the Constitutional Court in EFF. And therefore, my lord, whichever way you look at it, that relief must be granted. Then we were told that the public protector is not an employee. Well, my lord, that's with the greatest respect. That comes from one of the cases which I did in the Western Cape, which was Part A. In fact, both the cases you were given was the same case, basically. One was Part A by Saltana J, the other one by Bartman is when we did when we did Part B. And the only point that was made in both of those cases was that the National Assembly was not the employer of the public protector, and we haven't made any suggestion like that here. But what was said in the Constitutional Court, my lord, in the case, I think it's paragraph 48, your lordship will remember that in the pleadings, and for a different purpose, we referred your lordship to the Constitutional Court case of a Speaker versus Public Protector. Sorry, my lord. I'm so sorry. I know that we're running out of time. Yes, you'll find that, my lord, in at paragraph 21 of the founding affidavit. It's just a convenient place to find it. Speaker of the National Assembly versus Public Protector, 2022 3 SA 1 CC. That's paragraph 48. That's where the Constitutional Court affirmed that Bartman judgment that you were given, because it was in that judgment that, because of everything I've said, the court agreed with us that the public protector was entitled to legal representation. But in so saying, it said the following: there was a distinction which sought to be made between Section 89 and 219 for the purposes of the legal representation issue. And that distinction was this: the speaker was saying in that case, no, the reason why a president would have legal representation in an impeachment process is because there's a forfeiture clause. And the reason why the public protector should not have legal representation is because in her case there's no forfeiture of benefits. Remember, that's the word exactly used in 89.2, benefits. And we've already had that discussion. And we pointed out, my lord, that that distinction is artificial for that purposes. But the important thing is that the Planchla J, we spoke for the unanimous court, said the following. I'm just making the point about punitive. Said, look, I agree, differentiated with the removal of president and formalistic for that context, but here's the important one. The consequences, although not prescribed by the Constitution, for the removal of a Chapter 9 institution, office bearer, especially a head of a Chapter 9 institution, are grave. They are grave consequences.
Forgive me, Mr. Mpofu. I thought you were dealing with the issue of the public protector as an employee or not as an employee.
Yes, I am, but I was just rounding up the issue about the consequences, the punitive consequences.
Yes, but you have made that point already.
Okay, so I mustn't give you the reference, my lord.
No,
Okay.
I couldn't follow because
Okay.
you dealt with the issue of that one must shiver where one is to be faced with punishment, but is told that one won't have a hearing.
Yes.
We then got to the issue of whether the public protector was an employee. You referred me to this decision, but that's, on the face of it, it's got nothing to do with whether or not...
It has everything to do with it, my lord. I'm saying the decision that was cited by Mr. Mkhwebane in support of the opposite contention then went up to the Constitutional Court, which he didn't mention. He might not know. I know because I was in both cases, including the Constitutional Court one. So I'm saying that same decision that he cited to you of the Western Cape went to the Constitutional Court of South Africa.
Has the Constitutional Court said that the public protector is an employee or is not an employee?
No, my lord. Okay.
No,
I'm trying to save time, my lord, and I'm really trying to make the points. If your lordship... Okay, yes, let me...
Mr. Mpofu, you go to a heading about the submission made by Mr. Mkhwebane that the public protector was not an employee. You you then started by saying that the point is that in that decision it was said that the National Assembly was not the employer of the public protector. You then refer me to the decision of Speaker against the Public Protector, 2022 Volume 1 Constitutional Code. You made two points. You said it affirmed Bartman, and then you said it dealt with the Public Protector an entitlement to legal representation. That is why I'm a bit puzzled, because I thought you were addressing the court on the point of whether or not the public protector is an employee.
Anyway, all right. Let me put it like this. Let's forget about the Cape Town cases and the Constitutional Court. Because otherwise, the point is this, my lord. For you to be entitled to a remuneration under the BCEA, for example, which is really what the whole purpose of that discussion was. All that is needed is that you, and we all know this, and Mr. Ngatobi read that sentence and stopped. All it says, and I'm paraphrasing again for time, is that any payment, whether in kind and so on, which you receive because you work for a person, including the state. And it has exclusions, which are if you work for NIA or Defense Force, I think, and so on. So there is no, and the short title to the BCA says that it's an embodiment of Section 23(1), which says everyone has those rights, everyone. So except for those people who are excluded, everyone has the constitutional right in Section 23, and as well as in the BCEA context. And in any event, even the Western Cape case that Mr. Ngatobi referred to, I think it was paragraph 78 or something, the Saldanha judgment, said the following: the National Assembly or the Speaker is not an employee. It's determined in terms of this and that act, and in any event, her employment contract stays. So it's still referred to her employment contract, which is really all we need for the purposes of the BCEA, not the niceties as to whether, in terms of the LRA, for example, she's an employee.
I don't follow. Are you submitting that it is enough for a person to say that I have an employment contract, and on that basis the BCA then applies?
Yes, I'm saying, okay, maybe assist your lordship. I'm saying that the BCA says it regulates. I'm just looking for the definition. Anyway, you'll find the definition in of remuneration in particular, of in Mr. Ngatobi's heads. This is the point I'm making, my lord. Let me make it quickly. The persons, including judges, nobody needs to say a judge is an employee for a judge to be the subject of the Judges Remuneration Act, right? So a judge is simply not in their judicial capacity as the person who works for the state and has certain rights that flow from that office. And if, for argument's sake, this is really the point I'm making. If the Judges Remuneration Act said something like, you may not have any allowances, you may not have any benefits, that would offend against the very spirit of Section 23.
Forgive me, Mr. Mpofu, it really doesn't help the court where you are moving a case for the applicant who formerly held the office of Public Protector, but you are making submissions as to legislation that deals with judges.
No, my lord, I'm sorry about that. I really, my lord. Here we're dealing with the service conditions at 02185. At every twist and turn of this, there is references to judges. Every twist and turn. starting with the top, the first sentence, an annual salary at the rate equal to that of a judge, and so on and so on. You'll find that in 6 or 7 other places. So it's clear that the intention of the drafters of this thing was to create that congruity. So, and this thing was drafted specifically for the public protector, but it mentions judges in 100 places. So it can be that we must then ignore the context of the document. We must ignore the holistic language used in the document, and then just say, no, well, let's just focus on the public protector part. I'm sorry, that if that is well, anyway, for what it's worth, the broader point is this: that both these offices, and the reason why are those references is very simple, my lord, because both of those offices they are conditions of service to Section 219 of the Constitution, for the reasons I explained yesterday, for independence and so on. But I will let's only talk about the public protector. Anyway, so the broader point is simply that the definition in the BCA creates minimum conditions and is umbilically connected to Section 23 a la Musaneke. Then, my lord, yes, I've made the point about the use of the word shall, and anyway, your lordship's discussion on Welsh, it doesn't require any improvement. The only point I wanted to emphasize there is that the force of entitlement derives in the same way as GEPF and the others, as I've already said. Oh yes, the word that Mr. Mkhwebane used for the death thing was, he said it's a deemed vacation. But anyway, it's a vacation nevertheless. All right. The other absurdity is that, according to his interpretation, therefore the spouse of the public protector has a legal obligation, an entitlement, but the public protector doesn't have. And then I was insulted about no jurisprudential engagement on tautology, but waving of hands. Well, I suppose my references to R versus Simmons and all those cases were not jurisprudential enough. But in case that is so, this is the only submission I make. The presumptions, such as the presumption on tautology, are exactly that, presumptions. Those presumptions cannot be, there's a whole discussion in LOSA about the force of those presumptions, and especially in the constitutional era, as to whether they are still as useful, and some of them may have been discarded, others are still applicable, and so on and so on. I don't have time, unfortunately, to take the court to that. Simply to make the point that those
issues... Mr. Mpofu, I'm going to give you 15 minutes to conclude. That will take us to quarter to 5. The court staff do have to leave. So you have 15 minutes.
What is this? No, that's fine. Anyway, my lord, let's go to the next point. This one will come back. The sorry. Oh yes, it was about the role of the presumptions. So I'm saying, my Lord, while there is a number of cases, Your Lordship will find more than enough, which says that tautology is not uncommon in statutes. Bearing in mind, this is not a statute anyway that we're talking about, even though I was accused of making a submission that it is. Wrongly, because I never said such a thing. Your Lordship asked me the question yesterday, and I said it's that at best that document could be subordinate legislation because it derives from Section 2.2. But for the purposes of this case, it's a contract. But be that, that's just a series of things that were attributed to me, which I never said. The point is that you'll find an equal number of cases that says tautology is common. You'll find another number of cases that says courts should be slow to assume there's tautology and so on. But the point of the matter is that all the cases will say one thing and one thing only, that presumption is subject to the absurdity rule. All the presumptions, by the way, are subject to the absurdity rule. So if the clear language of the and construction of the statute or contract or whatever it is suggests, as I've demonstrated now, that there is tautology, for example, around the issue of death, then obviously the presumption cannot supersede the clear language employed. And, well, okay, I'm not going to go back to this exercise about demonstrating that remuneration and the gratuity is a part of the same scheme. I think we've exhausted that. All I just want to say is that what we call conditions of service, I think Christus makes this point, is simply a fancy word of saying terms. Those are terms of the contract. But sometimes the word conditions is used. But really, all those things listed there are terms of a binding contract. Oh, here's the issue. This is about this whole thing about discretion and so on. Mr. Mkhwebane makes a fundamental conceptual mischaracterization of the case, which Mr. Mudau, at least even though he shouldn't be here, has assisted in characterizing. When we talk about the discretion in relation to the service conditions, my Lord, we are talking about, it's true that there's a discretion of the National Assembly in promulgating those conditions. But I think Your Lordship zoomed into this. Your Lordship called it rules there. So the question then becomes, having that discussion having been exercised, what do the actual rules or conditions of service, or whatever you call it, contain, and what do they tell us on their construction? Mr. Mudau calls that the antecedent decision, and he's correct. So we're not here, as Mr. Mkhwebane seems to think, about that antecedent decision or discretion, or whatever you call it. We are here about just as the GEPF rules, all those things have their own antecedents. The question is, once they are there, what are they saying? And where they are saying there shall be this, there shall be this, there shall be that, then that's how we must construe them, and not be concerned about whether the antecedent decision was discretionary or not discretionary, or benevolent or not benevolent, or whatever the. So a good employer or a kind employer might include certain things in their package, and a stingy one might not include them. But both of them have the same equal force once they are in the document. Both the ones from the stingy one and from the nice and benevolent one. Once they've now received contractual force, then we must interpret them. So in other words, my lord, to put it simpler, if my learned friend Mr. Muela and I are car salesmen of the state, and then the state says, look, if you sell 10 cars, we'll give you a gratuity of so much, or a bonus, or whatever you call it. And then we go out, we both sell exactly 10 cars, and the state gives me the gratuity but doesn't give him. It doesn't matter that when this policy was made, it was out of kindness or whatever. He can go to court and say, here is a situation where there is no reason why there has been I've been treated this way. It's capricious. There was no hearing. Blah blah blah. All the things that we have said, and on that basis alone, there's a public right here. So the short story is that we're not testing the antecedent decision, but the subsequent one, which is before you. Then, my lord, we are told that I don't know if okay. I've made the point about legal personality. Section 182(2) of the Public Protectors Act of the Constitution deals with the public protector, the office, the person. And then Section 5 of the PP Act deals with the juristic person. I've already made that. And then as far as legitimate expectations are concerned, my lord, I don't know if I understood your lordship correctly. Your lordship was asking, presumably rhetorically, as to whether a public office holder can be a beneficiary of, or rather can have a legitimate expectation. Was that correct?
Well, broadly, the question was if a person is whether a public office bearer, such as a judge,
yes, can have a legitimate expectation.
Could invoke legitimate expectation as that expression is understood, for example, in the labor regime.
Yes. Okay. No, I don't know what the answer to that is. But
I suppose the point of substance is public office bearer,
yes,
who happens to be a judge.
Yes. Maybe not in the LRA sense. No, I understand, my lord. But that, with respect, is not the kind of legitimate expectation we're asserting here. Here we're asserting a legitimate expectation which arises from the Section 3(1) of PAJA, which says and that's why this whole debate about whether the thing, the service conditions gives you a legal right or not is just sterile, because even if it doesn't give you a legal right and only gives you a legal expectation, a legitimate expectation, it would still be actionable. And Section 3(1), my lord, of PAJA says the following, and there's a whole lot of academic discussion on this, but as it stands now, that's what it says. Administrative action which materially and adversely affects the rights or legitimate expectations of any person, whether it's a judge or a public holder or whatever, must be procedurally fair. So that's the genesis of and that obviously comes from Section 33. But even under the common law, my lord, the legitimate expectation doctrine is an obvious adjunct of Audi. And I don't want to go back to the discussion we had about Audi. But I'm just simply saying that if I say, if whether you're a judge or not, or a public office holder, if because of some practice, arrangement, agreement, or whatever, I give all the other judges something, and then I don't give you, then you are entitled to have a legitimate expectation that you'd be treated equal. Right. So the point is that it's everyone. Then, my lord, yes, page. Okay, I've referred your lordship to the question of reasons and illegality. Yes. Okay. This one takes the cake. So we're told that the letter of demand is representations. I mean, I don't know where that comes from. So somebody deprives you of a right, you write to them to say, please give me that right, and later they make a decision without giving you a hearing, and they say, no, your letter of demand was constituted a hearing. And nohal, that letter of demand suddenly now imposes a duty on you to say what kind of hearing. So at some of these submissions, really. Then, my lord, Sandpax have referred you. And the fact that it is said that there's no difference between the reasons in the letter and the answering affidavit, I've referred you. Now, the point I really want to make, my lord, is that the court, really in this case, is being asked to rewrite the Constitution. It is being asked to impose a punitive forfeiture clause which has no basis at all in any document that has been discussed here. But the court must fashion such a forfeiture clause. And that forfeiture clause reads like this. Whenever a public protector has been removed, depending on which version you, either in terms of section 194, if you go to the real reasons, if you go to the other reasons of the lawyers, which were put in the answering affidavit, then you can say for misconduct or incompetence. Wherever that has happened, that person will forfeit any entitlement, legitimate expectation, right, whatever, to their gratuity. Subsection 3. That person in that forfeiture
is clarified.
Yes. That person in that forfeiture, if I can just finish the submission.
This will be your last point.
That person in that forfeiture clause, this is now the new part of that, how the court must rewrite the Constitution, shall not have any hearing, shall not have any procedural rights, and shall not be told the ambit of the forfeiture clause as to what it covers or it doesn't cover. And anyway, your lordship will know where I'm going, and I know there's time. But all the things, the criticisms that we have put are supposed to be contained in this imaginary forfeiture clause with no rights that go with it, that whose purpose is merely to punish, is merely to deduct, is merely to take away that which has vested over 6 or 7 years without any notion of justice whatsoever. That's what this court is, in essence, if you cut all the frills, is being asked to do, is to fashion such a draconian forfeiture clause and sanctify it and give it judicial blessings. Well, if that is where we're going with the constitutional democracy and rights culture and the culture of justification and all the things that we said yesterday, well, then God save us all. And because that would be a spiral road to not just arbitrariness, but dictatorship and unilateralism of an order that one cannot even imagine, my lord. Surely, my lord, your duty is to say any office bearers, whether it's this one or another one, are entitled to the remuneration that is prescribed in the Constitution, which flows right to their service conditions, depending on who they are, or which flows to the Judges Remuneration Act, depending who they are, or the Auditor General, and so on. All the people mentioned in Section 2195. All of their rights flow from there to various instruments, and all those instruments must be respected and cannot be read in an oppressive in such an oppressive manner and arbitrary manner as the respondents would like us to believe. As the court pleases. My lord, I unfortunately didn't have time to address the question of costs. Simply to say that the suggestions that are made about that if you complain about bias...
I'll take note of that. I must stop you. The court officials, unlike most of us in this room, use public transportation and so forth, and the court is not going to impose on them for our convenience. But I've heard you. The court will reserve judgment, and I intend to deliver that judgment as quickly as is prudent to do so. And I do want to thank the court staff for obliging the court to sit as late as they did.
Do you want to talk to the court and the court staff?
Yes, the court will rise.
Oh, that's the one which paragraph 78. Yeah?
It's not that she's not able to contents.
Yeah.
She cannot, she doesn't
The status, yeah,
for the purpose
of that case, yes.
they wanted to move
Yes, I know. Oh, sorry, I'm keeping your things here nearby. Yeah. Who? Yeah. I don't know. That's because that's how they get paid.